next bill, I think. Weren't you taking the next bill? Secretary Reed, House Bill 318. 318.
House Bill 318 by Representative Stevens of the 164th. Bill to be entitled an act to amend Code Section 4883 of the OCGA relating to exemptions from sales and use tax and for other purposes. Senate Committee on Finance recommends that this bill do pass by substitute. Senate Finance Committee offers the following substitute to House Bill 318. Bill to be entitled an act to amend Part 1 of Article 1 of Chapter 8 of Title 48 of the OCGA relating to general provisions regarding sales and use, state sales and use tax and for other purposes. There is a fiscal note attached to the bill.
Chair recognizes Senator from the 8th. Present the bill.
Thank you, Mr. President. I come with House Bill 318, committee substitute. Does a couple of things. The main thing it does is reinstate the sales exemption for food banks on donated food, prepared or otherwise, which is a very good thing, and also allows dialysis equipment to be written off, tax exempt as well, and has one consumer item at the end. Very good bill, and I ask that you vote for this and help our food banks in particular in Georgia. Thank you.
You do have a question, Senator. If you sure. Chair recognizes Senator 42nd.
What's the consumer item at the end?
Oh, it just deals with the disclosure of the sales tax. If you include it in your price, you have to disclose it, that it's part of it. That's all it does. It's a good consumer item.
Questions on the adoption of committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any of the senator wish to speak for or against the bill? Is there objection? Agreed. Report of committee which favor pass the bill. Chair is none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question is ordered. Shall this bill now pass? Questions on the pass the bill. All those in favor of the bill will vote aye. Those opposed no. Secretary will unlock the machine. On the pass the bill, the yeas are 34 and the nays are 0. This bill, I'm sure, constitutional majority is therefore passed. Secretary will read HB 332.
House Bill 332 by Representative Parsons of the 42nd and others. Bill to be entitled an act to amend Code Section 465167 of the OCGA relating to the Universal Access Fund and for other purposes. Committee of the Senate on Regulated Industries and Utilities recommends that this bill do pass by substitute. Senate Regulated Industries and Utilities Committee offers the following substitute to House Bill 332. Bill to be entitled an act to amend Code Section 46.5.167 of the OCGA relating to the Universal Access Fund and for other purposes. Amendment number 1, Senator from the 48th offers the following amendment. Amend the Senate Regulated Industries and Utilities Committee substitute to House Bill 332 by inserting after increase on line 13 the following in the company service rates. Amendment number 2, Senator from the 48th offers the following amendment to substitute 332 by striking from lines 17 and 18 the words upon its approval by the governor or upon its becoming law without such approval and inserting January 1st, 2013.
Chair recognizes the Senator from the 48th, Chairman of the Regulated Industries Committee, one of the most powerful committees under heaven.
Mr. President, ladies and gentlemen, the Senate or House Bill 332 simply allows telephone companies to recover some of the money that they pay into the Universal Access Fund, so long as the methodology for that recovery is submitted to the Public Service Commission and approved by the Public Service Commission. The two amendments that you have in front of you, the first corrects a Scrivener's error in the substitute. There were 5 words that should have been included in the substitute that weren't, and when you add these words, the sentence makes sense. It doesn't really make sense the way it's written now. The second substitute changes the effective date from upon signature of the governor to January 1st, 2013, and this allows a transition time. This bill received, I think, the unanimous do pass recommendation of the Senate Regulated Industries and Utilities Committee, and I'd urge your favorable consideration. And if there are no questions, I will yield the will.
You do have a question. Chair recognizes Senator from 39th.
Will Senator yield?
Yes, sir.
Can you tell us what the Universal Access Fund funds? What does it do?
The Universal Access Fund is a fund created by state law that assists companies in providing service to high-cost areas. So basically, you know, it costs more to provide telephone service in a rural area where the houses are farther apart than it would be in a suburban or an urban area. And there is a fund created by state law that assists companies that serve those areas in providing that service.
Will Senator further yield?
Yes, sir.
Therefore, would this bill make it more difficult for those high-cost areas, rural areas, for example, as you said? Would it make it more difficult for those areas to get service if we were to pass this?
It actually should not affect that part of it one way or another. Right now, that fund is funded by contributions from all the telephone carriers, and under current law, they're not allowed to recover those funds by adding it as a line item on the bill. You'll notice on your bill, you'll see money on your telephone bill, you'll see money for a Universal Service Fund, which is the federal equivalent of the Universal Access Fund. State law doesn't currently allow them to recover that money as a line item. This bill wouldn't necessarily allow them to do it, but it would authorize the PSC to approve them to do that, provided that they submitted methodology that the PSC found acceptable to calculate that amount.
Chair recognizes Senator from 31st for a question.
Does Senator yield?
Yes, sir.
I have had phone calls from constituents about these ads they see on television where you can get a free telephone with 250 minutes, free unlimited text, those kind of things. Is the Universal Access Fund used to provide those telephones?
No, the Universal Access Fund only helps provide the traditional landline service, not any of the cellular services.
Chair recognizes Senator from the 18th.
Will the senator yield?
Certainly.
Senator, I think I was beginning to understand a moment ago, but I just want to ask the question again. Can you help us understand the problem this bill is seeking to correct or remedy?
Every expense that a business incurred is passed along to its customers. You know, if a telephone company is paying money into the Universal Access Fund or paying taxes or buying equipment, that the cost of that is ultimately passed along to the customer. That's its only source of revenue. What this bill would do, if it's passed, is allow the PSC to permit companies to recover those funds in a more transparent way. in terms of being, instead of being part of the overall price package, they could line out, this is what the cost of the Universal Access Fund contribution is.
Would you further yield?
Certainly.
Just one other quick question, Senator. Are the phone companies that this is would be applied to, are they in favor of this and having this regulated by the PSC?
They would be in favor, I mean, they would rather just be able to do it without any regulation at all, but since the current bill doesn't allow them to do it at all, they would certainly be in favor of this bill that allows them to do it with the PSC's oversight.
Would you yield for one?
Certainly.
Just following up on what you just said, what is the value of giving the PSC this additional regulatory authority?
Well, I think that, you know, if we simply permitted them to do that, we wouldn't have any, we wouldn't have any idea, we wouldn't have any way to determine whether or not the charge they were adding to their bill accurately reflects their cost. And so this bill simply allows the PSC to double check the math by reviewing the methodology they use to calculate that charge and give its final sign off to that amount being recovered in that way. I mean, it'll be recovered one way or another. This just allows it to be recovered in a more transparent way than it's currently being recovered.
Chair recognizes Senator from the 42nd for a question.
Will Senator yield?
Certainly.
Will this extra charge be spread throughout the customer base of these particular companies, or will it only be charged to people who receive a benefit from the fund?
No, it's spread everyone. I mean, I guess that would ultimately be a decision that the Public Service Commission would make, but it's my understanding that it would be charged equally against all the telephone customers. So every line would receive a approximately equal charge.
Okay. Thank you.
No further questions. Or no, I'm sorry, there is. A light just came on from the Senator from the 22nd.
Thank you, Mr. President. Does Senator yield?
Yes, sir.
Senator, in reference to this fee, if you will, do all telephone providers play in this space, or is it specifically just the ones, the Bells of the world? Do all of them play in this space, I mean, i.e. the Comcast of the world who provide telephone access?
When you say play in this space, what do you mean exactly?
Meaning, are they going to be participating in this universal access?
Right. You know, everyone who, I'm trying to remember the reform bill that we passed 2 years ago, but I believe that everyone that's licensed as either an incumbent or a competitive carrier is required to pay into the Universal Access Fund, and most of the cable companies that provide telephone service are, I believe, have licenses as competitive local exchange carriers, so they pay into the fund. That's correct.
And that would include those such as DirecTV and others as well, who are now providing local access, local telephone access? Are the Vonages of the world?
I believe that the Vonages of the world are required to pay into the Universal Access Fund under the reform bill that we passed 2 years ago.
Okay.
I believe.
No further questions,
Thanks.
Senator. Questions on the adoption of the floor amendment. The author has two floor amendments. Amendment number 1, is there objection? Without objection, amendment number 1 is adopted. Now the question is on amendment number 2. Is there objection? Without objection, amendment number 2 is adopted. Question now is on the adoption of committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree and report of committee which favor pass the bill. Chair is none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question is ordered. Shall this bill now pass? Question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. And the secretary will unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 3. This bill, I'm sure, erects constitutional majority, is therefore passed. The Secretary will read House Bill 334.
House Bill 334 by Representative Stevens of the 164th. Bill to be entitled now to amend Code Section 4883 of the OCGA relating to exemptions from sales and use tax and for other purposes. The Senate Committee on Finance recommends that this bill do pass by substitute. The Senate Finance Committee offers the following substitute to House Bill 334. Bill to be entitled now to amend Chapter 8 of Title 48 of the OCGA relating to sales and use tax so as to enact an alternative homestead option sales and use tax and for other purposes.
Chair recognizes Senator 21st, Majority.
Thank you, Mr. President. House Bill 334 would pertain only to the 3 counties that could be eligible to pass a host tax at some future date. They would have to do so, of course, via referendum, and that would be Cobb, Gwinnett, and Cherokee. So this bill would not pertain to any other county except those 3. If they were to pass a host tax in those 3 counties, this would be the alternative homestead option sales and use tax that they would follow. Under current host tax, the amount you collect is to be used to reduce the property tax, the general county property tax for homesteaded property, but there's also the flexibility to use it for capital expenditures up to 20%. You would still be able to do that in this bill. It would just simply put those in order that first you would reduce homestead property taxes, then general property taxes, and then capital expenditures would come third. But again, it would only pertain to those 3 counties if, in fact, they decided to pass a host referendum tax at some point in the future. If there are no questions, Mr. President, I will yield the well.
There is a question. Chair recognizes Senator from 22nd for a question.
Thank you, Mr. President. Does the Senator yield?
Yes.
Senator, can you show me or point me to the place here in the bill that exempts all, in this case, what would be the remaining 156 counties from participating in this? Is there something in here that?
There's no exemption because every one of those counties has reached the cap. They either have E-splost, regular splost, and lost. And once you have a lost or a host in some of those counties, you can't then pass another one. So the only 3 counties that are still eligible to pass a host or a lost are Cobb, Cherokee, and Gwinnett because they haven't reached that 7% cap. They're still at 6.
Okay.
No further questions.
I yield the well.
Question on the adoption of committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreed. Report of committee which favor pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. On the pass of the bill, the yeas are 47 and the nays are 2. And this bill, having received constitutional majority, is therefore passed. Chair recognizes Senator from the 54th.
Thank you, Mr. President. I ask unanimous consent to lay House Bill 347 on the table.
It's a great idea. How many more you want to lay on the table? You can knock. No, now, Senator from 39th, don't you start getting greedy on me now. Easy. All right, is there objection? Without objection, we will lay HB 347 on the table. House is not in. They're not coming back till 2:15. It's unbelievable. I mean, stay all day, stay a little longer, you know, it's unbelievable. Secretary Reed, House Bill 397.
House Bill 397 by Representative Powell, the 171st, and others. Bill to be entitled now to amend Title 50 of the OCGA relating to state government so as to comprehensively revise the provisions of law regarding open meetings and open records and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass. The Senate Judiciary Committee offers the following substitute to House Bill 397. Bill to be entitled now to amend Title 50 of the OCGA relating to state government so as to comprehensively revise the provisions of law regarding open meetings and open records and for other purposes.
Chair recognizes Senator Fifth-Fourth to present the bill.
Thank you, Mr. President. Thank you, members of the Senate, for the opportunity to present House Bill 397. As has been noted by a few of our colleagues today, House Bill 397 is a bill about open government, and it deals with our open records and open meetings laws. I want to commend the Attorney General of Georgia for his work and the work of his staff on looking at an opportunity to revise and clarify this code. This is a voluminous bill, and it deals with a lot of case law and history in the Open Records, Open Meetings Act that we've had in Georgia, and it brings our code current with what the courts have interpreted. There are a few provisions in there that change substantively. It clarifies some of the penalties. First offense would be $1,000 up to $1,000 maximum fine. A second offense within a single year would be up to a $2,500 fine. And one of the issues that I do want to bring to the Senate's attention is that there is one substantive change in the notice when we hire department heads or hire executive level in Georgia. The Board of Regents specifically indicated that the hiring of presidents of of our university system schools has become complicated by the notice provisions, and so that specific position has been shortened in terms of the amount of time that notice must be provided to the public before a candidate is named from the three finalists, and you will see that on page 21. The senator from the 42nd in committee caught that there was an error that the chancellor had been included in that, and that was not what the regents were seeking, just presidents. That language has been removed, so it is simply that one office that has changed. Mr. President, I could go through section by section, but I'm not sure that'd be productive. I would yield for questions.
No questions, Senator.
Thank you, Mr. President. I ask your favorable consideration.
Question on the adoption of committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreed to report of committee which favor pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put, or the objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those no, unlike machine. On the passage of the bill, the yeas are 46 and the nays are 0. This bill having zero constitutional majority is therefore passed. Secretary will read HB 456.
House Bill 456 by Representative Byrd of the 20th and others. A bill to be entitled an act to amend Chapter 4 of Title 50 of the OCGA relating to the organization of the executive branch generally, so as to establish the Georgia Government Accountability Act and for other purposes. Committee of the Senate on Appropriations recommends that this bill do pass by substitute. Senate Appropriations Committee offers the following substitute to House Bill 456. Bill to be entitled an act to amend Chapter 4 of Title 50 of the OCGA relating to the organization of the executive branch generally, so as to establish the Georgia Government Accountability Act and for other purposes.
Chair recognizes Senator from the 32nd. Present the bill.
All right. Thank you, Senators. I bring to you House Bill 456, which is almost identical to Senate Bill 223, except for one sentence. I'll explain that difference in just a moment. Many of you recall this bill and know it as the Sunset Bill because many Georgians believe that we deserve the right to regularly examine the purpose and effectiveness of our state government and its agencies and programs because over time some of those programs become obsolete, less of a priority, maybe not necessary. So the legislators who represent the people of this state should step in and look at possible ways to consolidate, privatize, or eliminate certain programs. This measure provides for a joint legislative committee that can request information from agencies and hold hearings to examine the agency and its programs to learn more about its priorities and help it become more efficient and possibly recommend reducing the size of government. The difference between the House and the Senate version, I applaud, and that's to do one thing. It adds the 2 members of the minority party to the legislative committees to guarantee that they are represented there, and so there's a House and Senate member, too, of this small committee that would be appointed, as well as 2 floor leaders, one from the House and the Senate. From what I understand, there are no amendments on the bill. There was a circulation discussion about such amendments, and I reserve the right to talk about that if such amendments were filed. I hope not. So I just urge you to once again, maybe for the 3rd, 4th, 5th time, to join together and support this measure to reduce the size of government, to fit our revenues, not increase our revenues, to reduce the size to meet the size of government. And I urge you to support the House bill as it's presented to you, so we can protect not only this principle for now, but for generations to come. With that, Mr. President, I'll yield for a question. Otherwise, I'll yield well.
You do have a question. Chair recognizes Senator from the 40th.
Senator Yield.
I do.
First of all, congratulations on the bill. I know you've put a lot of work into this over the
I'll
years.
do all over again.
And my question is, this does not apply, though, to like constitutional departments, i.e. like Labor Department, et cetera. It's just state agencies.
That's absolutely right. I was trying to be brief here, but yes, constitutional agencies are not subject to this review because they're constitutional agencies. Thank you. I'll yield the well.
The Senator from the 39th had a question. He's not going to take the Senator from the 39th. Hey, there's no Gucci stuff going on here. Are you going to Gucci on this one too? Okay. Chair recognizes Senator from the 39th.
Members of the Senate, Mr. President, if I'd had the opportunity, I would have asked what the governor's role in this process is. I would have asked, are we talking about doing away with these government entities by a simple vote of a majority of the body? I think those are questions that are reasonable, that should have been asked, should have been answered. we had a fuller discussion of this, of the Senate version when it was on the floor. I think we deserve a fuller version, a fuller discussion of it as it appears on the floor of the Senate. I am going to vote against it. I don't know if we have enough information at this point to vote for this bill. Mr. President, I yield the well.
Question on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agree in the Port of Committee which favor pass the bill? Chairs none. Port of Committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none. Main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the pass of the bill, the yeas are 38 and the nays are 6. This bill having received the constitutional majority is therefore passed. Secretary will read HB 463.
House Bill 463 by Representative Dollar, the 45th, and others. Bill to be titled an act to amend Code Section 332312 of the OCGA relating to limited licenses to provide for the sale of individual insurance coverages by limited licensees and for other purposes. The Committee of the Senate on Insurance and Labor recommends that this bill do pass.
Chair recognizes the senator from the 13th. I'm sorry, 54th. 54th. Present the bill. That's what I love about the senator from the 13th. He was quick on the draw, though. I don't have to call him twice, but then I can guarantee you.
Thank you, Mr. President. Thank you, members of the Senate, for the opportunity to present to you House Bill 463. House Bill 463 creates a limited insurance license, much in the same mode as is provided for in auto rental agreements, mobile phone industries. This time it is for self-storage units. This allows the owner of the self-storage unit, in conjunction with the rental agreement, to sell insurance to the renter, so that they can insure the products and items that are inside the unit. Mr. President, if there are no questions, I would yield the well.
No questions, Senator.
Thank you, Mr.
Does
President.
any other senator wish to speak for or against the bill? Is there objection? Agree in the Port of Committee which favor pass the bill. Chair is none. Port of Committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. The main question is ordered. Shall this bill now pass? Questions on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine.
On the passage of the bill, the yeas are 45, the nays are 3. The bill, having received the requisite constitutional majority, is therefore passed. Secretary will read House Bill 534.
House Bill 534 by Representative Fullerton, the 151st, and others. Bill to be entitled an act to amend Code Section 1594 of the OCGA relating to additional eligibility requirements in certain counties so as to modify the eligibility requirements and for other purposes. The Committee of the Senate on Judiciary recommends that this bill do pass.
Chair recognizes the distinguished senator from the 13th, Tift County.
Thank you, Mr. President. Distinguished members of the Senate, I guess you need to be ready at any time. But anyhow, this is a population bill. It does not change the law. The community simply wants the right to require their probate judge to be a lawyer. And I might add that the senator of the 12th is in favor of this bill. It affects part of her territory. If there are no questions, I will yield the well.
No questions, Senator. Does any other senator wish to speak for or against the bill? Is objection to agree in the report of the committee which is favorable to the passage of the bill? The chair has none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair has none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor of the bill will vote yea. Those opposed, nay. And the secretary will unlock the machine. On the passage of the bill, the yeas are 41, the nays are 4. The bill, having received the requisite constitutional majority, is therefore passed. Secretary will read House Bill 634.
House Bill 634 by Representative Sheldon of the 105th and others. Bill to be entitled an act to amend Code Section 48524 of the OCGA relating to installment payment of ad valorem taxes and for other purposes. The Senate Finance Committee recommends that this bill do pass by substitute. Senate Finance Committee offers the following substitute to House Bill 634. Bill to be entitled an act to amend Chapter 5, Title 48 of the OCGA relating to ad valorem taxation of property and for other purposes.
Chair recognizes Senator 48th to explain the bill.
Mr. President, ladies and gentlemen of the Senate, the bill before you is actually an amalgamation of 3 population bills. The House Bill 634, the original bill preserves the method for partial payment of ad valorem taxes in Gwinnett County. It's been amended to include the provisions of House Bill 407, which apply to Cobb County, and also to a third bill that affects Grady, Peach, and Jones counties. I would urge your favorable consideration of this legislation, and if there are no questions, I will yield the well.
No questions, Senator. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is objection to agree in the report of the committee which is favorable to the passage of the bill? The chair has none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair has none. The main question is ordered. Shall this bill now pass by substitute? The questions on the passage of the bill. All those in favor of the bill will vote yea. Those opposed, nay. And the secretary will unlock the machine.
On the passage of the bill, the yeas are 46, the nays are none. The bill, having received the requisite constitutional majority, is therefore passed. Secretary will read House Bill 665.
House Bill 665, Representative Maddox of the 127th. Bill to be entitled an act to amend Titles 9, 15, 44, Chapter 18 of Title 50, and the Code Section 3695 of the OCGA relating to civil practice, courts, property, state printing, and documents, and for other purposes. Senate Committee on Judiciary recommends that this bill do pass by substitute. Senate Judiciary Committee offers the following substitute to House Bill 665. Bill to be entitled an act to amend Titles 9, 15, and 44, Chapter 18 of Title 50, and Code Section 3695 of the OCGA relating to civil practice, courts, property, state printing, and documents, and storage of documents, and for other purposes. Amendment number 1. Senator from the 54th and others offers the following amendment. Amend the Senate Judiciary Committee substitute to House Bill 665 by inserting after cross references on line 21 the following. To amend Chapter 12 of Title 15 of the OCGA relating to juries so as to clarify that certain persons shall be ineligible to serve as trial or grand jurors, and for other purposes. 1066.
Chair recognizes Senator 54th, Whitfield. Explain the bill.
Thank you, Mr. President. Thank you, members of the Senate, for the opportunity to present to you House Bill 665. House Bill 665 comes to us from the clerks of the Superior Courts of the state of Georgia. It is a comprehensive bill that primarily deals with streamlining and modernizing the process for maintaining records. It allows for the disposal of records that have been digitized in many cases. It also clarifies the process for the removal of a clerk, which was vague and is vague in Georgia law. That has been done in conjunction and with agreement with the Superior Court judges of Georgia. And Mr. President, without going section by section, I will address Amendment number 1 and then yield for questions. Amendment number 1 is a House bill by Representative Atwood that clarifies an error in last year's passage of the jury composition bill. You will recall we did a large bill on that. The senator from the 46th led the charge in the Senate to improve the way we select juries. There was an ambiguity in that law that may have allowed felons to serve on petit juries and grand juries in Georgia. Certainly that was not our intent. It's not appropriate. And so Amendment 1 is the language from Representative Atwood's bill that didn't make it out of rules. Obviously our clerks help us make juries in Georgia every day. And so, Mr. President, if there are no questions, I would yield the well.
No questions, Senator.
Thank you, Mr. President.
Questions on the adoption of the floor amendment by the Senator from 54th and two other learned scholars of the legal profession. Is the objection to the adoption of the floor amendment to the committee substitute? Hearing none, the floor amendment of the substitute is adopted. Questions on the adoption of the committee substitute as amended? Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass as by substitute? Questions on the passage of the bill? All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine.
What purpose? On the passage of the bill, the yeas are 43, the nays are 0. The bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 9th.
President, I ask that House Bill 707 be tabled until the person presenting it gets back from across the hall.
The senator from the 9th has moved that House Bill 707 be laid on the table. All those in favor of the motion will rise, stand, and be counted. Favor. Laid it on the table. We got an objection. All those in favor? Got an objection. Reverse. One. On the motion to lay 707 on the table, the yeas are 28, the nays are 2. It's on the table. Ladies and gentlemen, you have completed the first page. We've got 4 more to go. Secretary will read House Bill 744.
House Bill 744, by Representative Lindsay, the 54th, and others. Bills being titled an act to amend Part 2 of Article 7 of Chapter 6 of Title 44 of the OCGA relating to partition so as to enact the Uniform Partition of Heirs Property Act and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass.
Chair recognizes the senator from the 46th to explain the bill. '46th.
Thank you, Mr. President. Ladies and gentlemen of the Senate, this is the Uniform Partition of Heirs Property Act. It is to get Georgia in line with most of the other states in the nation, giving an easier way to handle the division of property when it's inherited, either through a will or intestate, when multiple heirs own property together in small portions. For example, if a grandparent died and you had 8 or 10 grandchildren that each had 1/8 or 1/10, this is to make it easier for them to sell out their portion or to divide the property so they could cash out if they're no longer interested in keeping that small share of the property. It allows them to get a valuation of the property either by consent or through the actions of the Superior Court judge. Once the property is valued, any person that wanted to sell the property can pay that appraised value. If there are more than one person that wanted to buy the share that somebody wanted out, they would be able to buy it in the equal percentage of their ownership of the property. It expedites this process and avoids the legal process called a partition of property, which requires it to be sold through an auction process on the courthouse steps or divided by the court. If there are no questions, I'd urge your favorable consideration of this bill.
No questions, Senator.
Thank you.
Does any other citizen wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. What purpose is Senator Rice?
Thank you, Mr. President. I ask unanimous consent to excuse the senator from the 9th for business outside the chamber.
Senator is excused. Shall the bill now pass? The questions on the passage of the bill. All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine. On the passage of the bill, the yeas are 43, the nays are none. The bill having received the requisite constitutional majority is therefore passed. Secretary will read House Bill 786.
House Bill 786 by Representative Hembry, the 67th, and others. Bill to be entitled now to amend Chapter 57 of Title 33 of the OCGA relating to the Consumer's Insurance Advocate and for the purposes. Senate Committee on Insurance and Labor recommends that this bill do pass. Amendment number 1, Senator from the 48th, offers the following amendment to House Bill 786, striking from lines 46 and 47 the words "upon its approval by the governor" or "upon its becoming law without such approval," and inserts July 1st, 2012 in their place.
Chair recognizes Senator 48th to explain the bill.
Mr. President, ladies and gentlemen of the Senate, it's my privilege to present House Bill 786. This bill is a paperwork reduction act. There exists in statute an insurance consumer advocate who is part of the Governor's Office of Consumer Affairs. This position has not been funded for the last 8 years, but the requirement that insurance companies send duplicate copies of all their filings to that office remains intact. What this bill simply does is says that as long as that position is not funded, that insurance companies are not required to make filings to that office. The amendment simply changes the effective date. The bill came out of the Insurance and Labor Committee with a unanimous do-pass recommendation, and I urge your favorable consideration. If there are no questions, I will yield the well.
No questions, Senator. Chair never ceases to be amazed at things that come in style and go out of style and go away. Questions on the adopt? You have a floor amendment? You have a floor amendment? You have an amendment? Have two amendments, ladies and gentlemen. Questions on the adoption of the floor amendment by the senator from the 48th, sponsor of the bill. Is there objection to the adoption of the floor amendment? Hearing none, the floor amendment is adopted. Is that it? Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass as amended? Questions on the passage of the bill? All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine. On the passage of the bill, the yeas are 44, the nays are 1. The bill, having received the requisite constitutional majority, is therefore passed. Secretary will lead House Bill 808.
House Bill 808 by Representative Yates, the 73rd, and others. A bill to be entitled now to amend Code Section 48727 of the OCGA relating to the computation of Georgia's taxable net income and for other purposes. Senate Committee on Finance recommends that this bill do pass. There is a fiscal note attached to the bill.
Chair recognizes Senator 56th to speak to the bill. 56th.
Thank you, Mr. President. This is a simple bill to help our veterans. It is to make sure that anyone who has been disabled while in combat, whether they be National Guard, reservist, or regular military, will all fall into the same guidelines, that their disability would never be taxed, and that's for those who have gave so much to our country. I ask for your favorable passage, and I'll yield the will.
No questions, Senator. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? The main question on the passage of the bill, all those in favor of the bill will vote yea, those opposed nay, and the secretary will unlock the machine. On the passage of the bill, the yeas are 43, the nays are 0. The bill, having received requisite constitutional majority, is therefore passed. Secretary will read House Bill 818.
House Bill 818 by Representative Parsons of the 42nd and others. Bill to be entitled an act to amend Code Section 48729.4, Port 14 of the OCGA, relating to the income tax credit for clean energy property and for other purposes. The Senate Committee on Finance recommends that this bill do pass by substitute. The Senate Finance Committee offers the following substitute to House Bill 818. Bill to be entitled an act to amend Code Section 48721.14 of the OCGA, relating to the income tax credit for clean energy property and for other purposes.
Chair recognizes the distinguished senator from Houston. Explain the bill.
Thank you, Mr. President. House Bill 818 basically is dealing with alternative energy. As all of you know, this nation has had no energy policy since the 1970s of any value. And what we're really addressing mainly in this bill is natural gas for transportation. It's a tax credit for buying mainly heavy-duty trucks and buses, and also we added taxis in there, and I did that because I was talking to the mayor of Atlanta one day, and I know that he really wants to change out the fleet of taxis servicing the airport here in Atlanta, which I think is a great idea, so we added them in there also. This bill sunsets in 4 years, and at that time I don't think that it needs to be brought back up and brought back to life. This is a way to help get this moving in the state of Georgia, not only from more competitive fuels for transportation, which will help all the businesses in the state of Georgia that change over to natural gas, but also from an air quality standpoint. As we know, EPA keeps tightening down the standards on air quality, and getting in non-attainment would be detrimental to businesses, any of your military installations across the state of Georgia. So we think this is a very good way to help out, to really help ignite this moving forward. We've worked hard with the governor's office on this, and the House, Representative Parsons, who was willing to take my bill and start in the House because it is a tax credit, has done a fantastic job. And we really have to not stand around and watch anymore. We've been doing it since the 1970s, this country has. It has been a bipartisan effort to have no good energy policy in this country. And so we're going to do our little bit to help here. We've worked with the T. Boone Pickens Group, and they are going to invest a lot of money in fueling stations. So we're trying to get them to end the natural gas highway. It's going to start on the West Coast and end on the East Coast, and we think we're going to be able to get them to end that at the port in Savannah. And we think that'll have a very positive impact for the state of Georgia and for business in this state and for air quality and for more source of affordable fuel for transportation. With that, I'll be glad to answer questions or yield the will.
Questions? Senator 41st.
Thank you, Senator. We have a lot of bills today, and I was just looking. The cap, is it still in place? Is there an annual cap in the amount?
Yes, it is. That's a great question. I appreciate that. It's capped at $10 million a year for 4 years. So we know what the top is, and that's what we work with. Actually, we start off at a lot higher number than that, but we work with the governor and the budgets and all those issues, and we've finally settled down at about $10 million a year for the cap. And that's the total cap also, so it can't go over that per year, and that's just for 4 years. But I think it'll have a huge positive impact on the state.
Chair recognizes Senator 33rd for a question.
Senator Yield.
Well, you know, Senator, I will, but I didn't see your wife here today, and she's by far the most superior part of the family.
I apologize for that. I know she wants to see you too. Do you?
Well, you know, me and her got something going on. We just ain't
Lord
told
have
you about it. Go ahead, Senator.
You're going to take the credit card bills. Let me ask this, Mr. Chairman. Isn't this a way that we can do something environmentally and can afford? And these are the steps we can take that make big things out of little things. And
you're right.
It's been pretty well vetted, hasn't it?
This, by putting this amount of money in, even though we took it down from about 25 million down to 10, because we gotta be responsible about the budget process. By doing this, it's going to have a massively big impact on this state, and it's going to get more money invested into the state for fueling stations. And that's private dollars coming out of other people's pockets coming into this state. And air quality wise, it's going to have a huge positive impact.
Thank you, Mr. Chairman. Good bill.
Thank you. Thank you very much.
That's all I have, Senator. That's it.
What's that?
No question.
No other questions? Thank you very much. I appreciate your favorable vote.
Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? Questions on the passage of the bill? All those in favor of the bill will vote yea. Those opposed, nay. And the secretary will unlock the machine. On the passage of the bill, the yeas are 41, the nays are 4. The bill, having received the requisite constitutional majority, is therefore passed. Secretary will read House Bill 822.
House Bill 822 by Representative Lindsay of the 54th and others. Bill to be entitled now to amend Chapter 3 of Title 23 and Chapter 4 of Title 49 of the OCGA, relating to equitable remedies and proceedings generally and public assistance and for other purposes. Senate Committee on Health and Human Safety Services recommends that this bill do pass by substitute. Senate Health and Human Services Committee offers the following substitute to House Bill 822. Bill to be entitled now to amend Chapter 3 of Title 23 and Chapter 4 of Title 49 of the OCGA, relating to equitable remedies and proceedings generally and public assistance and for other purposes.
Chair recognizes the senator from the 3rd to explain the bill. Whoa, let's give the senator your attention.
Thank you, Mr. President. This bill provides that those who are submitting false claims for the Medicaid and other programs can be subject to civil penalties, including subject to suit for recovery of the funds that they have fraudulently obtained first by the Attorney General. If he chooses not to pursue it, then the local entity, government, could do it. Or if not, the person who's the whistleblower could be authorized by the Attorney General to pursue that themselves. And this is designed to protect the taxpayers from having our tax money fraudulently taken and stolen by those who are not ethical and who are cheating the system. So it's a good bill, and I would ask your support. And Mr. President, unless there are any questions, I'll yield the well.
I have no questions, Senator. The question is on the adoption of the committee substitute. Is there any objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair has none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair has none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill. All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine. On the passage of the bill, the yeas are 42, the nays are 0. The bill, having received the requisite constitutional majority, is therefore passed. Is he ready? Irene, is he ready to bring it off the table? Secretary, read House Bill 827.
House Bill 827 by Representative Hembry, the 67th, and others. Bill to be entitled now to amend Article 15 of Chapter 6 of Title 40 of the OCGA related to serious traffic offenses so as to modify provisions relating to fleeing or attempting to elude a pursuing police vehicle and for other purposes. Senate Committee on Public Safety recommends that this bill do pass.
Chair recognizes distinguished Senator from Baldwin.
Thank you, Mr. President. House Bill 827 simply makes some editing changes to the Georgia Code in reference to fleeing and eluding a police officer. This was brought to us by folks in the court system, but it is approved and supported by the Georgia State Patrol, the Georgia Association of Chiefs of Police, and the Georgia Sheriff's Association. I'll be happy to answer questions. If there are none, I urge your favorable support of House Bill 827.
No questions, Senator. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair has none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair has none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine. On the passage of the bill, the yeas are 47, the nays are none. The bill having received the requisite constitutional majority is therefore passed. Secretary will read House Bill 846.
House Bill 846, by Representative Knight of the 126 and others. Bill to be entitled an act to amend Title 48 of the OCGA relating to revenue and taxation so as to change various administrative and procedural requirements of the Department of Revenue and for other purposes. The Senate Committee on Finance recommends that this bill do pass.
Chair recognizes Senator 16th, distinguished floor leader for the governor of Georgia.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I rise today to speak to you on House Bill 846. This is a Department of Revenue bill, and there are three sections to the bill. And what we're doing here is allowing the Department of Revenue to publish redacted letter rulings, which benefits the taxpayers and tax preparers. We're also giving the department more flexibility in tax sales in order to try and achieve the highest price they can for some of these tax sales with the state, and also providing that a tax lien or tax execution in electronic form shall be treated as an original for all purposes. We're just trying to update the code a little bit for the Department of Revenue, and I will be happy to answer any questions, Mr. President.
Are there any questions? I have none, Senator.
Thank you. I yield well.
Does any other senator wish to speak for or against the bill? Is the objection to agreeing to the report of the committee which is favorable to passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? Questions on the passage of the bill? All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine. On the passage of the bill, the yeas are 46, the nays are 1. The bill having received the requisite constitutional majority is therefore passed. Secretary will read House Bill 851.
House Bill 851 by Representative Rice of the 51st and others. Bill to be entitled now to amend Code Section 48673 of the OCGA relating to reports and distributions regarding the taxation of intangibles and for other purposes. Senate Committee on Finance recommends that this bill do pass by substitute. Senate Finance Committee offers the following substitute to House Bill 851. Bill to be entitled now to amend Code Section 48673 of the OCGA relating to reports and distributions regarding the taxation of intangibles and for other purposes.
Chair recognizes Senator 56 to present the bill.
Thank you, Mr. President. Fellow senators, I bring you House Bill 851. This is actually a simple bill that just sets a uniform rate of 6% for all counties used to calculate the Commission of Officers Collecting Taxes. Specifically, DeKalb and Fulton would no longer receive disparate treatment under existing population. Both Fulton and DeKalb County are in agreement with this as well. If there are no questions, I would ask for your favorable passage and yield the well.
No questions, sir. Questions on the adoption of the committee substitute? Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill. All those in favor of the bill will vote yea. Those opposed, nay, and the secretary will unlock the machine. Hey, man. On the passage of the bill, the yeas are 46, the nays are none. The bill, having received the requisite constitutional majority, is therefore passed.
Secretary will read 861.
House Bill 861 by Representative Harden of the 28th and others. Bill to be entitled an act to amend Chapter 1 of Title 35 of the OCGA relating to law enforcement officers to require law enforcement agencies to report drug-related arrests to the Department of Human Services and for other purposes. The Senate Committee on Health and Human Services recommends that this bill do pass by substitute. Senate Health and Human Services Committee offers the following substitute to House Bill 861. Bill to be entitled an act to provide a short title to provide a statement of legislative intent to amend Article 9 of Chapter 4 of Title 49 of the OCGA relating to temporary assistance for needy families so as to define certain terms and for other purposes. Amendment number 1, Senator from the 2nd and others offers the following amendment. Amend the Senate Health and Human Services Committee substitute to House Bill 861 by adding "and" at the end of line 49 and replacing "and" with a period on line 53 and by deleting lines 54 through 60 and for other purposes.
Chair recognizes Senator from 56 present the bill.
Thank you, Mr. President, fellow senators. We have a lot of bills on the calendar today, and I'm not going to be repetitive. This is the exact language that this body passed out a couple of weeks ago, which was Senate Bill 292, which is the Social Responsibility and Accountability Act. I realize it's an amendment. I will have one more amendment forthcoming in a moment to protect those who are in nursing homes and elderly from this. But because we've already debated this bill at length, I'm going to yield the will.
Question. Chair recognizes Senator from 36 for a question.
Thank you, Mr. President. I'm just coming back in from the hall. Are you planning to take questions on the bill as the author of the original language that's been substituted in, Senator?
If there is new questions, I will take new questions, but not ones we did 2 weeks ago.
And whose encyclopedic memory will determine whether or not this was discussed 2 weeks ago?
I feel certain you have a great memory, Senator.
Well, indeed. And voters have even longer memories, I've heard tell. Is it not true? What is the real purpose of singling out low-income women who are raising their children for drug tests when there's no indication? I mean, have we got a heroin-using population out there laying in the gutter? Is that the problem we're trying to address? I mean, what really is the flag that this particular population of very poor women, mamas, grandmamas, and aunties, who are doing their very best to raise small children and get a lifetime limited 4 years TANF check, what really singles them out to be subjected to a drug test and the cost thereof?
Senator, as I mentioned, we already went through a series of these questions, I believe, specifically with yourself. And this absolutely keeps it equal between all parties, those who are working in the private sector, those who work in the civil service, so all people are treated the same. But due to time, I'm not going to continue to answer the same questions we answered 2 weeks ago.
So
at
the
that,
author-
Mr. President, I'm going to yield the well.
So the author's yielding the well.
Senator has yielded the well. Chair recognizes Senator from the 42nd. I tell you, we've had late arriving amendments. Please read the amendments. They are being printed, by the way.
Amendment number 2, Senator from the 41st and others offers the following amendment. Amend the Senate Health and Human Services Committee substitute to House Bill 861 by adding "and" at the end of line 49 and replacing "and" with a period on line 53 and by deleting lines 54 through 60 and for other purposes. Amendment number 3, Senator from the 49th and others offers the following amendment. Amend the Senate Health and Human Services Committee substitute to House Bill 861 by replacing lines 29 through 34 with the following. As used in this code section, the term applicant or individual means a parent of a dependent child applying or reapplying for TANF benefits and for other purposes. Amendment number 4, a senator from the 36th and others offers the following amendment. Amend the Senate Health and Human Services Committee substitute to House Bill 861 by inserting after matters on line 9 the following. To provide for a contingent effective date and for other purposes. Amendment number 5 by Senator Carter of the 42nd. Amend the Senate Health and Human Services Committee substitute to House Bill 861 by adding after assistance on line 62 the following. And who the department has reason to believe is using illegal drugs.
Whose amendment? Chair recognizes Senator from the 2nd to speak to his amendment.
Thank you, Mr. President. I have a very simple amendment. This eliminates the requirement to charge applicants who have Medicaid a non-refundable Medicaid fee. Let me say this again. Amendment number 1 eliminates the requirement to charge applicants who have Medicaid a non-refundable Medicaid fee. This is very simple because why are people on Medicaid? They lack necessary funds. And why are we charging them an additional tax? Because when we charge them a non-refundable fee of $17, we are taxing the least of us. And that's not what this body should be about, taxing the least of us. So I see this fee as a tax. I see it as a disservice to the poor. TANF people need help. And it's our job as this body in the Senate to give them some sort of relief. But instead, we are giving them a tax. In addition to this requirement, it just helps the Medicaid victims. You know, Medicaid may not even reimburse the applicants because this may not be medical necessary. So they may pay this tax, but Medicaid may not be reimbursed because Medicaid only reimburses medically necessary items. So I urge you to support this amendment. If there are no questions, Mr. President, I yield the well.
Who has amendment 2? No. Oh, you wish. Chair recognizes Senator from 10th. Question.
Thank you, Mr. President. Senator Yield?
Yes, sir, I yield.
Senator, in looking at the substitute on House Bill 861, why do you think TANF families, which is on the lower end of the socioeconomic ladder, why do you think TANF recipients are being targeted for this kind of legislation?
I have, Senator, great question. I have no idea why we're targeting the least of us. I have no idea why we're targeting people who have nothing, that are coming to government for assistance, and then we're giving them a tax to receive assistance. I have no idea why this body would do such a measure.
Senator Further Yield?
I do, sir.
Senator, I noticed on, not on the substitute, but on the original bill, House Bill 861, it has some language in here that some would find offensive. Let me just kind of read it to you what was on the original language. It says on line 15, it says the use of legal drugs by those on the lower end of the economic scale makes it more likely that such persons will remain in poverty and commit other criminal offenses. Senator, have you seen any data to suggest, quantitative or empirical, that would suggest that those on the lower end abusing drugs would be any different than those on the upper end abusing drugs?
Senator, another great question. That's quite the opposite. We found out that people on the upper end have used drugs because they have more access to drugs. We got to understand, illegal drugs cost money. People on the lower end of our economy do not have the necessary funds to receive those, to even buy those drugs. Nor can they buy those drugs with their food stamps or their food stamp card. We need to be about the business of protecting the least of us, and this legislation does not do that.
Senator, further yield?
I do, sir.
Some other language that was being tossed around, and Senator, I have to read this to you. It says, whereas serious drug abuse by lower income parents is more likely to result in children of impoverished families failing in schools, developing emotional behavior problems, or being neglected or abused. Is there any reason to suggest that just because someone is poor or impoverished that they would neglect their kids in any way versus those that may have a lot more wealth and affluence?
Absolutely not, Senator. From the 10th, there's nothing to suggest that low-income families do not strive to do great things in this great state, do not strive to be great citizens. It's nothing that indicate that low-income people do not have the best in their heart for their children, that they're not standing up for the right things. They're just trying to get out of poverty. And we should offer opportunities for low-income families instead of having a deterrent. And this is a deterrent for low-income people, and I urge our members to defeat this bill and also vote for my amendment.
Senator, further yield?
I do.
Senator, these are the type questions I would have liked to ask the Senate sponsor of this bill. Unfortunately, he yielded to Wells, so if you don't mind yielding for another question.
I yield.
Senator, it would appear to me that this particular bill targets the least in our society. Is it not true, Senator, that those that can qualify for this minuscule benefit really survives on about $250 a month?
Yes, you're absolutely correct.
So wouldn't it also, if the Senator would further yield, wouldn't it also be prudent for this body to allocate funds to cover the cost of these drug testing that they're mandating under this legislation?
Absolutely, absolutely. If we're going to mandate that they're going to have drug tests, they should be fully funded, or not refund, but we should fully refund it and give them opportunities to have a free test.
Senator, further yield?
I do, sir.
Senator, given that those that receive these benefits are already surviving off of a very minuscule amount of money, wouldn't it be an economic hardship of a huge proportion for this particular family to be subjected to an unfunded mandate like this?
And an unfunded mandate like this, the families are going to have to make a choice. Drug tests or milk for their children. Drug tests or diapers for their children. Drug tests or books. Drug tests or going to the doctor. Drug tests or doing something useful for their family. So it is a tax for the least of us, and this should be defeated.
Senator, refer the yield?
I do, sir.
Senator, isn't the recipient of TANF benefit children?
Absolutely.
Would the Senator yield?
I do.
Senator, wouldn't you agree that this legislation would be very damaging to our children?
Absolutely, but because we're not taking away from adults. Although adults apply and they receive TANF care, but what we will do take away are children. We will take away from children. Children will have less access to food. Children will have less access to medical care. Children will get less access to attention.
Senator, further yield?
I do, sir.
Senator, in your private practice, have you seen, had some experience with poor people that really need, say, dental care, and you've been able to provide that free of charge?
I do, sir, every day, but every day. And it's not just me, it's many healthcare professionals see the poor and the working poor. And what they need is help. They don't need to be taxed, they don't need to be burdened, and they don't need to be treated like criminals. And what we do is this legislation treat the least of us as criminals.
And if the senator will yield for one final question?
The senator yields.
Senator, isn't it true that a lot of private and charitable organizations help with providing these type services? So given that being the case, why is it the state coming down on those that can least afford it in the state of Georgia with this type of onerous legislation?
Well, Senator, that is a good question. I have no idea why this body is attacking the least of us. We should be looking at bringing everyone together, moving everyone forward, and we cannot do that as long as we tax the least of us, as long as we do unnecessary taxing on the people of this great state. Mr. President, I yield the will. Thank you.
Okay, Senator from the 2nd spoken to his amendment. Senator from the 41st be recognized to speak to amendment number 2.
Thank you, members of the Senate, Mr. President. Line 62 to 65, I have inserted language and made some changes that will say that if someone is not covered under Medicaid benefits, it will cover the cost of the medical testing, drug testing, then the individual will not have to pay themselves. That pursuant to paragraph 9, subsection B of this code section, the state will pick up the cost. And similarly, in sections 81 through 86, changing the cost to be bared by the state. You know, the burden to these individuals is great. They have very little, if enough, money to eat, and to be forced to pay for these drug tests just creates another unseemly burden, which often makes it difficult for them to feed their families and their children. These people often don't have enough money to drive or catch a cab to go to these places. They have to walk miles and miles to even go for drug testing. So this amendment will make sure that the state, who feels necessary to make sure that there's no drug usage in these individuals receiving TANF, will pick up the cost for the test. This protects the state because they now have the results. They can use it for the purposes they need to make sure that drug money is not going, money of the state is not going to someone that may be using drugs, but it puts the burden where it should be. And of course, our benefits are very low. These are people making under $780 a month and getting a very small benefit. They're already having a very tough time meeting the needs of these children and their families. So I urge you to put the cost on the state if we move forward with this process, and I urge you to adopt amendment number 2. If there's no questions, I'll yield the will.
There are questions. Chair recognizes Senator from the 35th.
Will the senator yield?
I certainly yield for my colleague from the 35th.
Thank you very much. Isn't it true that the Office of Legislative Counsel has issued an opinion on this bill stating that this legislation could face serious constitutional challenge and be a financial burden on the state of Georgia if we vote it up?
Well, thank you, Senator. I appreciate it. As you know, this has been challenged in other states legally. I think you also know the financial burden and cuts that have been made to this department and others. So it does mean that we will probably end up spending some of our valuable and short supply state resources in litigation on this,
Whereas if we wait a year or two, that issue at least might be cleared up. The overall issue of whether or not this is good public policy, where we're possibly going to cut off benefits of someone whose children are the ones that need to be affected, and as a state don't offer counseling or other mechanisms to protect the children and the family. You know, there are a lot of concerns with this bill that it's focusing on one thing, kind of addressing a media hot button of drug testing. We're not really going after the big problem or addressing more substantive issues, you know, that I think would be better for the individuals and for the state as a whole.
Thank you. Will you further yield, Senator?
Yes, I yield.
Isn't it true that the Georgia Department of Audits and Accounts have criticized the study that the authors of this bill put forth on this bill? For example, they said that they counted out of 574 TANF applicants that were as drug-related denials, only 9 were really you know, having some kind of drug-related problem, and out of that 9, most of it was prescription medication.
Yeah, I think the senator knows of which he speaks. Certainly, there were mentions of additional costs that they didn't include that may come up. And as you are saying, there has been many statements that there is not a significant problem with TANF recipients on drug usage. It's not like a pervasive problem much greater than the rest of society. And as you know, these individuals, by and large, by the very fact that they can qualify, have very little money. So, you know, sustained drug use is problematic for even those that do have a problem.
Yes, will you further yield, Senator?
I yield.
Isn't it true that since Florida was the model for this bill, and now Florida, who has used the same tactics, are saying that only 3% of those who they have paid to be tested for drugs, only 3% of them had any kind of drugs in their system?
Thank you, and that's a very important point, that it's a low number of people having drugs, and we've spent a tremendous amount of time dealing with issues like this, I think, to draw attention from the fact that Georgia, you know, has created problems that has increased the TANF recipients, created one of the slowest growth job state in the country, and of course, certainly one of the lowest income states in the country, based on policies and other decisions that I think we should be spending more time on than these few thousand just TANF recipients.
And one final question, if you will yield, sir.
I'll certainly yield for you. Thank you.
Isn't it true that we start out our sessions every day by praising God and calling on the Lord with a minister of the day, and we have many senators who come to that well and talk about scriptures and give scriptures and call on the good book. I call it my instruction book. And isn't it true that that in those cases, some of those people are supporting this legislation when the good book clearly says that we should take care of the least among us, because Jesus said, whatever you do to the least of them, you've done unto me.
Thank you. That's very great points.
Thank you so much, Senator.
Chair recognizes the senator from the 26th.
Thank you, Mr. President. Will the senator yield?
I certainly yield.
Thank you, Mr. Chairman. Senator, isn't it true that the caseload for defects eligibility workers are twice as high as they were in 2004, which essentially means we're going to increase their workload, increase the workday, which is going to cost the state more money?
Thank you. Actually, many times over, the caseload, you know, has risen in the last 7 years. It is an incredible amount of work. It is far above any standard acceptable amount of caseloads per employee. And yes, we are adding additional work to the state employees who have to double check on this, have to make sure, check the paperwork, make sure it's happening, make sure that there's no falsehoods and that there are appropriate tests done. And so it does create a lot more work in an overwork system, and we're not putting the money to really address those extra problems.
Senator, will you further yield?
I yield.
And isn't it true that there is this concept of Atlanta, Georgia, and the rest of Georgia?
There's certainly been talk for years of the two Georgias, the Atlanta area and the rest of Georgia, and there's certainly differences in some cases.
You further yield.
I yield.
So this rest of Georgia that is rural, how are these applicants to get to testing facilities within the allotted amount of time? Some don't have transportation. Do you agree?
Well, Senator, I know that you are kind of in that middle world of between Atlanta and the southern wide expanses of the state of the Senator 14th and others, and you have discussed many of the burdens that are created in those areas where you may not have a pharmacy close, you may not have a doctor's office close, and you certainly don't have a lot of availability for these testing opportunities, and it can create burden, especially in rural Georgia.
For one final question, Senator, will you yield?
I yield.
And isn't it true that we determined that the $17 fee is at best a minimal fee for these people that are already in a difficult financial situation?
Well, first of all, I have concerns about a year from now, us knowing for sure that they're actually getting this test done for $17. But $17 is a significant amount to someone who is eating macaroni and cheese and giving their kids water instead of milk and barely making it for, some of these families with 3 or 4, 5 children. They have to make less than like $780 a month. So you're talking, if you have multiple children, very little amount of money to qualify, and it's certainly a big amount of money to some people.
Chair recognizes Senator from 34th for a question.
Thank you, Mr. President. Will the Senator yield?
I yield.
Senator, does not TANF stand for Temporary Assistance for Needy Families?
Absolutely. I'm glad you spelled that out.
Senator, will you further yield?
I will yield for your series of questions.
Senator, will this bill help any family member get help if they are found to be on drugs?
That is a certain problem with this legislation, that it does not go beyond just the test and prohibition from benefits. What we need to do is, if we're looking at people that have problems, realizing they are part of families with children, is to have intervention, have counseling, have programs that protect the children and allow this individual to get back as a tax-paying individual if they have a significant or a real problem with drugs. So, no, this program is simply a punitive test and punish kind of thing, and it, as mentioned before by another senator, the caseload is so tremendous, and the situation with defects of children dying in custody and other problems we've had, that I am concerned that the needs of the children are not going to be addressed or helped at all by this, but we're going to put more resources of the state into making sure that people are tested, but not trying to solve the problems.
Senator, would you yield again?
Yeah, I continue to yield for your series of questions. You don't have to ask again.
Senator, is it not true that I was very excited to learn that our governor was now talking about trying to help those in our state who are incarcerated that has drug problems, to try to rectify some of that, until this bill came that started what I call slapping around families and mothers in particular for having maybe having an addiction problem with no means of trying to help them.
Thank you, Senator. That's important. The governor did make some initiatives of trying to deal with incarcerated individuals who have had some drug problems. He wants to try to get them back into the workforce and back as taxpaying citizens. I think we can all appreciate that that needs to be done for the long-term greatness of our state. We also need to be more, I think, progressive when we look at these individuals and their problems and trying to deal with this situation.
One final question, Senator. Isn't it true that drug addiction strikes from the lowest to the highest? And once again, we're looking at the have-lotters being able to mask their addiction, where the have-notters are being slapped around, taken off programs, and being unable to take care of their families because they are doing some of the same things, maybe, that some of the well-offs are doing. Is that not true, Senator?
Thank you, Senator. Yeah, I do agree that seems like we should be requiring possible drug tests for those with million-dollar contracts and other types of functions for high-level executives that are employed by state government, rather than starting at the bottom, the poorest, neediest people in Georgia first, and testing them. Second of all, as you know, one problem that a lot of people don't think of when they think of drug testing is, there are different types of drugs and different times that the effectiveness of the drugs are in the system. So somebody could use one drug, clean up for 2 days, and test and get the TANF. Another person might be in a room with marijuana smoke and test positive for 30 days. So, and never, well, I don't know if they want to say never inhaled, it might be some skeptical, but that not had a high content of marijuana in their system and still test positive. So, there are a lot of degrees here. It's never as simple as it seems, and we know that state is challenged with what it can do. Seems like this is, again, kind of going to a media firestorm rather than being the kind of work that in the long run will yield results to improve the lives of Georgia's children.
Thank you, Senator.
Chair recognizes Senator 36.
Thank you, Mr. President. Does the leader yield
Yeah,
to
I yield.
a series of questions?
I certainly, you don't have to ask again as long as my time allows.
Thank you very much. Fiscal note, fiscal impact to the state. There is no fiscal note attached that now, correct me if I'm wrong, but I don't see a fiscal note in what's been laid on our desks. Have you seen a fiscal note?
No, I do not. I remember we asking for one in committee. I can't remember, but I know that there's not one there on my desk.
That's right. And isn't this true that this is going to have costs attendant to, if this bill is to become law, there will be costs to the state?
Well, after I lead the well, Senator from 36, I would, myself or you, we can ask for a physical note. I think it is important to know exactly what the costs are, but regardless of what the costs are, as we discussed in committee, it seemed like the benefits would be very slight, and the allocation of state resources, no matter how small, would be better done somewhere else. Plus, the net effect of putting many young women or family members through this testing has in itself psychologically negative effects that really probably aren't worth the benefit. Plus, some people may not have transportation, get drug testing and other problems, and if they are delayed in getting this help, we may think, oh good, the state saves money. But in fact, what we do is we take money out, food out of the mouths of children, which later causes more serious health costs and other problems for the state down the road that cost more. This is a very low-cost program, which by doing, we are actually saving the state money, because ultimately we are not going to let young children starve to death in this state. And TANF, temporary assistance for needy families, is an important program to do just that, and do so in an effective and low-cost way.
Isn't it true, you're aware that in the bill it calls for reimbursing the cost of the drug test to some of the recipients? Are you aware of that? Reimbursing that the Department
Yeah.
of Human Services would put back in the, give back to the recipient the cost, the out-of-pocket cost for the drug test. Now,
But it doesn't do other costs associated with that. And of course, my amendment goes further in making sure that they're, made whole.
exactly, and from what any of us in the 21st century know about technology, and any of us, like the chairman of our Appropriations Committee, anyone that's dealt with our health budgets, knows that making changes to a computer program have cost. You've got to change software, design software. If anytime you have to go in and hand adjust, manually adjust, so to speak, on a case-by-case basis, what's going to be issued to a beneficiary, all of that, it has cost, both in personnel cost and in software cost. Isn't that just on its face as simple as easy for anyone to see and understand that there are costs when you start trying this cockamamie plan of refunding somebody a $17 test or whatever that the cost of the test would be?
The senator from the 36 is certainly experienced, has been at the Capitol for more than 20 years and was active in the community as a active person at many levels, and she knows for what she's speaking on these matters, yes.
And finally, you were in all the committee meetings, as I was, on the bill that this author originally penned and passed out of committee. And you heard the Department of Community Health, did you not, say that Medicaid would not reimburse a non-medical expenditure such as this?
Absolutely, and that's, again, a part of the reason for my amendment.
Exactly. And finally, did you ever, or did the committee ever have an opportunity to see any authenticated piece of paper which demonstrated that the cost of a swab testing for illegal substances in the body was $17? Did your eyes ever fall on, did the author ever present such a piece of authenticated paper to the committee, to your knowledge?
No, I didn't see anything more than what was put in a paragraph somebody wrote. I didn't see anything directly from the company, invoice, or more data on that, which I would have liked to.
And isn't it true that, and this may not be your direct knowledge, but we have knowledge of an extensive survey of laboratories in this area of the state asking for the cost of a drug test swab, and that cost was nothing like $17, that in fact they ran in the range of $30 to $35.
That is correct, Senator. Some of the stuff we saw showed a much higher expense, and therefore I do have concerns about that. More importantly, I think it is important to note this is not a department bill. It wasn't something they felt compelled to bring to us. It was more individual senator, and I know we all have concerns brought to us, and certainly we have people out there worried about bad people getting benefits from the state. We don't want that, but it's our role as 56 individual senators here to make sure that when one of us responds to a constituent's concerns, that we really cull the process, we evaluate all the dynamics of a bill, we decide, is that the best place to invest $8 or the right thing to do for people? And I think everybody will come to the conclusion that at least Amendment 2, the right thing to do is pass this amendment so that the burden of the cost for these tests come from the state, and then we can move on to the other dynamics of the bill from there.
Thank you, Senator.
No further questions, Senator.
Thank you.
Chair recognizes Senator from 39th on amendment number 3.
Mr. President, members of the Senate, this is a very simple amendment. I call it the Good Samaritan Amendment. It is unfortunate that in our time, parents oftentimes are not able to take care of the children that they have, and grandparents and aunties and uncles take care of those children in foster care. Those Good Samaritans, those Good Samaritan grandparents, aunties, uncles should not be made to take a drug test. And all this amendment would do is excuse those grandparents, those uncles, those aunties from taking the drug test as they keep those children in foster care, as they take care of their those children that we all care about most. That's all that this amendment does. It does not obligate, it requires that those parents take the drug test, but not those grandparents, uncles, and aunties. That's what this amendment does. Mr. President, members of the Senate, I commend it to you, and I would hope that I would implore you to vote for this amendment. Mr. President, I'll yield the well unless there are questions.
No questions, Senator.
Thank you.
Chair recognizes the senator from 36 speak to her amendment.
Thank you, Mr. President. Good afternoon, colleagues. I have an amendment that is before you on your desk, amendment number 4, an amendment, an effort to in some way mitigate the onslaught of this bill, which I find, frankly, to be, if you want to look for a low point in the legislative session this year, this is a strong competitor for a low point. And that is a bill that beats up on the little people. A bill that demonizes folks who are at the very bottom of the income strata in our state and who are participating in a national, federally funded program, temporary assistance to needy families, which is limited by law to 4 years for an applicant. I call this the lowest point in the session, and also I call it an integral part of the ongoing war on women. Why, you ask, would I call this part of the war on women? When you look at the roles of the TANF recipients, the TANF families, overwhelmingly it is moms, grandmoms, granddads, aunties, sisters-in-law, great-aunts. It's women overwhelmingly that stepped up to raise their children in a difficult economic time, all-time low for jobs, all-time high for unemployment, and who need the help of that tiny little TANF check to barely keep their heads above water. And this, ladies and gentlemen, that's who we're choosing to pick out and demonize. We're not talking about testing college students that are going to get a Hope Scholarship, are we? That thought ever occur to anyone? My goodness, that's a big fat benefit. We could ramp that up. How would that ring through the Ivy halls and around the state? Middle-class parents who've worked hard to get their kids educated into college wouldn't appreciate that much. But it's fine and dandy to cook up a drug test and portray poor women raising little children as drug addicts, dope addicts, fiends, heroin users, snorting lines of coke. It is nonsense. It is a storyline that is fueled by some very hateful ideas about low-income people. And that's why I call it a war against women, and that's why I call it a low point in the session, which we have visited and revisited. I don't know how many times we went at this bill in the Health Committee. We had fiscal note after fiscal note in the Health Committee that don't appear on your desk now, because every time a problem would be pointed out, the author would go back and I'll change these 3 lines, and presto, gesto, magic, all of a sudden we have a drug swab test that's only $17 with no paper brought to the committee. I say to you, there was no certificated information about the cost of a drug test. There were concerns expressed by Legislative Counsel about the constitutionality of this. We had fiscal notes that were 2 and 3 pages long expressing that this was going to cost money. I am offering the information to you that when we sought independently to confirm a $17 drug swab from any of the labs around town, we didn't get the $17 answer that the senator gave us in committee. We got $30 to $35. That was the range of 4 of the different big labs that are routinely testing huge populations in the Atlanta area. So that on that one fact alone, you're saddling the state with the cost of a program. I remember, and Senator 14th remembers this. We used to, and this is back in the late 80s. People were still sorting out what HIV was, and there were bills introduced and dropped almost every day of the session. Let's test people when they're getting married for AIDS. Let's test people when they're getting buried for AIDS. Let's test them when they show up at the foot doctor for AIDS. Let's put them in jail if they don't tell the foot doctor that they're HIV positive. We went around the state. Let's brand them. Let's have them have to wear a tattoo. Oh Lord, yes. We heard all of that demonizing a population, demonizing a subset of the population. We don't have to go down this ugly road. I think it's morally reprehensible. And near about 90% is my guess of us sit up in a Sunday school class on Sunday mornings. And with part of that remaining 10% sitting up in a synagogue or a temple. Maybe 1 or 2 in a mosque somewhere. But we go to our houses of worship and we hear about lifting up the least of these. What did Jesus stand for? Looking out for the poor, looking out for the little people. We could go to quoting a lot of biblical verse about this. I think there are over 1,000 entries in the Bible where Jesus is quoted about addressing the needs of the poor. But this is what the Georgia General Assembly brings to us. This is what we're asked to do for the little people in this session. That's why I call it a low point in the session. That's why I call it part of the war against women. Last week, we all joined together in great bipartisan unity. Didn't have a bit of trouble passing a tax bill that took us 4 days from start to finish. Remember that? Got unveiled Monday morning in the special committee, House in the afternoon. Thursday afternoon, we're casting a vote on the floor. Do you know we gave business a $167 million tax cut with a stroke of a pen in this bill? We didn't blink twice, did we? We didn't blink twice. And that's just a piece of what we did in that bill. That's just a piece. That's just one piece, that the energy phase-out piece. That's what that was. So we can deal up here in hundreds of $millions, glad hand and free hand, when it comes to the businesses of this state. But Lord have mercy, get down to a little woman who's barely got money to keep the lights on in her small little home, barely able to put food on the table. Children being raised who are already starting out with a crippling disease of poverty that very few escape from. And this is our answer to them. That's why I would ask you to vote for this amendment number 4, which quite simply is language that was carefully crafted by the attorney from the 3rd in a bill which he has brought before us and which has passed the Senate. Use this language that you will see in amendment number 4. And it's section 4. It says this act shall become effective only if funds are specifically appropriated for purposes of this act in an appropriations act making specific reference to this act, and shall become effective when funds so appropriated become available for expenditure. If you're utterly convinced we need to be testing mamas, grandmamas, and aunties and great aunts of little poor children, if you really firmly believe that, do it in a way which protects the taxpayers of this state and protects our budget and does not blow another hole in it when we can ill afford it. Support amendment number 4 and be able to say you did the right thing. And again, I would refer you to the language. This was crafted and presented by the senator from the 3rd, a learned attorney, and is common sense. It's a fiscally conservative approach to this bill. Mr. President, if there are no questions, I will yield the well. I'm happy to yield for questions, but if not, I'll yield the well.
You have a well, no, I think he walked off, so that's fine.
Thank you.
Yes, thank you, Senator. Chair recognizes Senator from 42nd to speak to his amendment, amendment number 5.
Thank you, Mr. President. I rise in support of Amendment number 5. Amendment number 5 merely renders this constitutional or attempts to do so. Right now, we are about to pass a bill that will violate the Fourth Amendment of the United States Constitution. Now, we have stood here in this chamber, the senator from the 56th, the senator from the 52nd, multiple other people whom I respect in this particular way, who have defended the right to avoid an unreasonable or an unconstitutional search and seizure. We've talked about cameras on the roads. We've talked about fingerprinting people. We've talked about a host of things that protect people's rights to privacy and the rights to be free from a government intrusion in your life with no reason. Amendment 5 does one small thing. It does not impact the substance of the bill, but for this. It says it allows for drug testing from people who receive assistance, quote, and who the department has reason to believe is using illegal drugs. If you search someone, require a drug test, intrude into their private lives for no reason, with no reason to believe that they've been using illegal drugs, not only is it wrong, but it's unconstitutional, and we will be litigating it and litigating it and litigating it. In fact, the Florida law was enjoined by the Middle District of Florida for this reason. Now, we've talked about jobs, and I know that we've already talked today making fun of me being a lawyer, but we don't want to create jobs necessarily for lawyers at taxpayer expense on this bill. And we will do that absent this amendment. This amendment not only preserves the rights of those people who are attempting to drug test and comports with the beliefs that I know many of us share, conservative or not, about the right to privacy and the rights under the Fourth Amendment of the United States Constitution. If there is no reason to test people, you cannot have the government test them. That's all this amendment does. If there's no questions, Mr. President, I'll yield the well, but I would urge consideration of Amendment number 5.
Chair recognizes Senator from the 10th for a question.
President, would the senator yield?
Yes.
Senator, I was intrigued by your comments and your remarks regarding the constitutionality of this particular bill. You are an attorney, is that correct?
Correct.
And you do know something about the law?
I know something about the law, but I don't know how much.
Would the senator yield?
Yes.
Senator, we are all public officials, and we receive benefits from the state, is that correct?
That is correct.
Senator, I recall some of the other legislators that have been here a lot longer than I have mentioned that at one time we were drug tested. Is that correct? Are you familiar with that?
I have heard that is true, and I'm sure that the senator knows from which he speaks.
Senator Yale?
Yes.
Senator, aren't you familiar with the Supreme Court decision that struck down the law that was created in this chamber where members of this body was drug tested?
I am, again, I have heard of that law, and I know that you know of what you speak.
Senator, further yield?
Absolutely.
Senator, if the courts struck down the law where we were drug testing ourselves, why would you think members of this body would think the courts would uphold the drug testing of poor people receiving government benefits?
There is no reason to make a distinction between any two people, frankly, in the world for drug testing unless the government has reason to believe that they're using illegal drugs. That would apply to legislators, it would apply to firefighters, it would apply to anybody that the government of Georgia is attempting to intrude upon their life. And you cannot say constitutionally, we're going to test you for no reason, whether you're a legislator or a recipient of TANF benefits.
Thank you, Senator. I appreciate your comments and your expertise on this matter.
Thank you, Mr. Chairman.
Chair recognizes Senator from second.
Gentleman in the well, do you yield?
I'll yield.
Are you, Senator, are you familiar with similar legislation in Florida like this?
I am. I have some knowledge about the similar legislation in Florida and the litigation that ensued and the constitutionality determination by the Middle District of Florida.
Are they still implementing this measure in Florida?
This measure in Florida, as I understand it, has been enjoined, and the injunction is now pending in the 11th Circuit Court of Appeals.
Senator, do you further yield?
Yes, I'll yield.
Do you feel that if we should pass this bill, will we face similar injunctions?
I would assume so. I would assume so, absolutely.
Thank you, sir.
And to make one final comment on that question, Mr. Senator, the 11th Circuit has yet to rule on the constitutionality of this. They will rule imminently, although it could take a very long time. When I clerked on the 11th Circuit, we had cases for 18 months sometimes without a ruling. But there's no doubt that the constitutionality of this is questionable. The morality of it is questionable if you are testing people for no reason. And you can solve both of those problems with Amendment number 5.
No further questions, Senator.
Thank you.
Senator from 3030, you wish to speak to the amendment, or? Okay, well, let's let the senator from the 56 speak to his amendment. You're recognized to speak to your amendment, Senator.
Thank you, Mr. President. You have Amendment 6 in front of you. Throughout this process, we worked very closely with all parties with special needs, disabilities, those in nursing homes, and the elderly to make sure that we were exempting the proper people throughout this process. And I want to thank each one of those groups for working so closely with us. If you look at Amendment number 6, this adds some additional language with some community-based services, specifically in the non-Medicaid homes. This is a good amendment to the bill, and it is the only one as the author that I will be supporting at this time. And I will yield the will. Thank you.
Chair recognizes Senator from 33rd. Speak to the bill.
Thank you, Mr. President, ladies and gentlemen of the Senate. Let me give you, again, as the senator from the 14th would say, a little history. We were both here at the time that these things changed a little bit. I happened to serve, and it was honored to serve as chairman of the Protection for Children Committee for Lieutenant Governor Pierre Howard. One day, in that committee hearing, one young man challenged me. He challenged me to go with him and go into some of these homes. And I said, I don't see why not. I think you're right. Somebody ought to, from this place that's trying to change things, might ought to see it. Well, that young man about this big around, about that tall, in a small little economy car, I got in the car with him, and we went into some homes and some of the projects in Atlanta that would have scared the devil. We went into a home where a little girl was sitting in the middle of a room on just a mattress, and she was suffering from a venereal disease she had caught from her grandmother's boyfriend. We went into another house, and this young man starts questioning this woman to make sure that she should be receiving these payments, and a big old fellow walks in and sits down. He's three times bigger than I was. And that young man just sat there and pointed his finger and said, "What are you doing here?" And I said, "Oh, no." But the young man had the courage of a lion. And he cared about those children, those homes he was going to. Was there drug abuse there? Probably. That was called AFDC, Aid to Families with Dependent Children. Now, Tommy Olmstead, who was a commissioner, former senator and commissioner of DHR at the time, changed it to TANF. Now, they're right. The national average is about 3 times, Georgia is about 3 times the national average in cases for caseworkers that they don't pay much of anything. Well, by the time some of these rural children aren't able to gain a Hope Scholarship, and they're drug tested, their parents are drug tested, or grandmothers without transportation. They've got a lack of health care because maybe the House put back in the shortage of OBGYNs there in rural Georgia, and they have no way to get 100 miles, which is my understanding in some counties, Senator from the 14th and others, they would have to go. They have no transportation and no drug testing facility. They're going to be in trouble. I want you to understand that the drug testing thing that we went through, I was there. Senator from 14th was there. I think we took them for about 3 or 4 years. I don't remember. But I know it was $39.95. I don't forget $1. Now, that's more than twice what we thought it was, isn't it? Thank you, but that was. Oh. But I don't usually drop $1. They don't report back that quick. I almost find maybe they're better at it now. I'm sure they probably are. They probably get instantaneous results. I hope they can, because I know one year I waited too long and the test wasn't back, and qualifying closed Friday. And I got in about an hour and a half before they closed and got elected, and I know you wish that hadn't happened, but it did. But, you know, when we do these things, I want you to know who you're affecting. Now, listen to this. It sounds good on the surface. But last year, there were 38,500 people receiving TANF. One-parent homes, grandmothers, mothers and dads, whatever. That's dropped by $2,000. I mean, $2,000, excuse me. I got $1 on the mind. That's dropped by 2,000 people to 36,800 on its own, with hopefully the beginning of a improved economy. But let me explain to you, 23,000 of those were children. So what are you going to do when you cut them off? You're assuming that not $1 goes to the child to feed him or her. 2/3, 66%, 66.5%. 2/3 of the people you're going to cut off, no matter what their parents' problem is, are kids. And that's what it's for. Aid to families with dependent children, temporary assistance to working families, is that it? I'm not sure. At any rate, I think it's good for us to know every now and then what some of these things that sound so good do. We can be proud of cutting 23,000 children off this thing if everybody were to fail. So we're not affecting the user as much, and we're not affecting what we want to do with this portion of the bill. And I'll tell you something else. Someday, somebody's going to add these things up and tell you what the court cost was. We've had a few court cases that cost us $5 or $6 million. And with the things we passed through here the last 2 years, buddy, someday somebody's going to tell us how much we spent in court when we knew it was unconstitutional to begin with. Not a good idea. Anyway, no question, I'll yield.
Question is on amendment number 1. Was you? All right. Question on amendment number 1. Is there objection? There is objection. There is objection to amendment number 1. What purpose you rise, Senator from the 41st?
For a roll call vote.
All right. Shall the ayes and nays be sustained? Clearly 5 having voted. All those in favor of amendment number 1 will vote aye. Those opposed no. Secretary will unlock the machine. Chair recognizes Senator from the 2nd.
Inquiry, Mr. President.
State your inquiry.
Isn't a yes vote will speak up for the least of us and not tax the poor?
I know the Senator has great passion for which he speaks. Chair recognizes Senator from 56.
Thank you, Mr. President. Isn't it true that the author does not support and would ask everyone to vote no on this amendment?
I think I think the senator has shared his views. Chair recognizes Senator from the 41st.
Parliamentary inquiry, Mr. President.
State inquiry.
At the completion of the amendments and when we have a perfected bill, would it be appropriate to ask for a fiscal note?
We will weigh that measure when we get to it, if we do. On amendment number 1, the yeas are 17 and the nays are 33, and amendment number 1 is lost. Now we go to amendment number 2. You wishing the ayes and nays? All those in favor of amendment number 2, authored by the senator from the 41st, will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes senator from the 56th.
President, parliamentary inquiry. Isn't it true that the author does not want amendment number 2 either, and that this bill also already had a fiscal note and was passed in its identical form just a couple weeks ago? Thank you.
Sure the senator has knowledge. On amendment number 2. The yeas are 17 and the nays are 34. And amendment number 2 has lost. Questions on amendment number 3? Ayes and nays? All those in favor vote aye. Those opposed, no. Secretary unlock the machine. What purpose, Senator from 39th, rise?
Parliamentary inquiry, Mr.
State
President.
inquiry.
Isn't it true that this is Good Samaritan Amendment that would not require grandparents and other caretakers as foster parents to be required to take the drug test that we are debating today?
Sure, the senator knows from which he speaks. On amendment number 3, the yeas are 17 and the nays are 33, and it has lost. Question now is on amendment number 4, authored by the senator from 36. All those in favor vote aye. Those opposed, no. Secretary will unlock the machine. What purpose, senator from the 36, rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that this is a fiscally conservative approach to take to say that when we appropriate the funds to cover the cost of this, that we would then move forward with implementation?
No, the senator has great passion for which she speaks. On the amendment number 4, the yeas are 16, nays are 34, and amendment 4 has lost. Now the question is on amendment number 5, authored by the senator from the 42nd. Wish the yeas and nays? All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. Amendment number 5, authored by the senator from the 42nd. Senator from the 56 is recognized. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that I do not support Amendment number 5 and that during the fiscal note process that went through committee and was presented for this exact bill just 2 weeks ago, it showed a positive budget impact of $103,000 to the Georgia budget?
I'm sure the senator knows from which he speaks. Senator from the 42nd, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that on every legislator's desk is a letter from Legislative Counsel detailing the constitutional problems with this bill if we do not pass Amendment 5?
I'm certain the senator knows from which he speaks. He's holding the letter up. On the amendment, the yeas are 17, the nays are 32, and the amendment has lost. Question now is on amendment. Senator from 33rd, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
I'm sorry, I may be a little early, but isn't it true that we hire a pretty good-sized staff of attorneys here
Staff of attorneys where?
in Legislative Council?
And yeah, it's made up. That's what they do.
Isn't it true that I just wanted to call attention to everybody that we just got a letter that questions the constitutionality of this?
Very good. Chair, Senator. The question now is on the floor amendment authored by the senator from the 56, amendment number 6. All those in favor, rise, stand, and be counted. If you're in favor, rise, stand, and be counted. Chair recognizes Senator from the 45th.
Is it not true that this amendment protects people through the SOURCE program, CCSP, long-term care, and nursing homes?
I'm sure the senator knows from which she speaks as the chairman of the Health and Human Services Committee. Reverse. Oh, why didn't I just unanimous consent? Chair the yeas are 32 and the nays are 1. And the amendment has passed. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of committee on which favor pass the bill? Chair is none. Report of committee is agreed to. All of those in favor of the bill will vote aye. Those opposed, no. And the secretary will unlock the machine. Chair recognizes Senator from the 14th.
Mr. President, in practical terms, is it possible to ask the House representative that sponsored this legislation to supply the defects offices of this state with drug testing locations within each given county?
I think anything's possible, Senator.
We represent a lot of counties that have no medical facilities, no doctors, no hospitals, no drugstores, certainly no drug testing places. I'd like to know where these people would go to be tested for drugs nearby.
The senator has clearly standing up for rural Georgia. On the passage of the bill, the yeas are 36 and the nays are 15. This bill, having received Rex constitutional majority, is therefore passed. The Secretary will read House Bill 896.
House Bill 896 by Representative Coleman of the 97th and others. Bill to be entitled now to amend Part 2 of Article 3 of Chapter 8 of Title 48 of the OCGA relating to sales tax for educational purposes and for other purposes. The Committee of the Senate on Finance recommends that this bill do pass by substitute. Senate Finance Committee offers the following substitute to House Bill 896. Bill to be entitled now to amend Part 2 of Article 3 of Chapter 8 of Title 48 of the OCGA relating to sales tax for educational purposes and for other purposes.
Chair recognizes Senator from the 37th, the gentleman from Cobb County.
I apologize as I bring to you House Bill 896. I know it's not going to be nearly as riveting as the last bill we considered, but this bill deals with the division of tax proceeds for educational SPLOST in districts or in counties that have more than one school system. We will, in a short while, consider House Resolution 1150 that deals somewhat with the same situation. This bill, House Bill 896, though, makes a stipulation that in those counties that have multiple school districts, if one of the districts is less than 3,000 full-time equivalent students, they can come up with a negotiated formula with the other districts. If all of them are over 3,000 students, they will be divided on a pro rata basis of the total tax receipts divided by the total number of students in the county. In attending all of the districts, and the division will be on a pro rata basis as percentage of total students. I'll be glad to entertain any questions that you may have on this bill. Mr. President.
No questions, Senator.
Thank you very much.
Chair recognizes Senator from the 45th speak to the bill.
Thank you, Mr. President. Members of the Senate, and for you new folks that are here in the Senate for the first time, the city of Beaufort, which I represent in Gwinnett County, has been under attack and under siege, in my opinion, for about the last 5 years, and I have fought off FTE counts because it punished one of the best school systems in the state of Georgia, if not the very best school system in the state of Georgia, in my personal opinion. I am agreeing to this bill. I would like to raise it to $3,500, but in the spirit of cooperation, I'm going to agree to it. Beaufort City Schools has 3,241 children. I believe this bill specifically targets them and targets one other school system, and but that's the way it's been for the last 5 years. I am going to agree to the bill, but I just want to go on record as stating how many times we have had to fight for the money that we get in the Beaufort City school systems, but yet even though we're fighting, we're still one of the best in the state of Georgia. We have a waiting list to get into that school system because it is the best. With that, Mr. President, I'll answer any questions.
There are no questions,
Thank
Senator.
you very much.
The question is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreed. The Report of Committee which fail pass the bill. Chair is none. Report of Committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question is ordered. Shall this bill now pass? Questions on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlike the machine. On the passage of the bill, the yeas are 51 and the nays are 0. And this bill, having received requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 30th.
President, I ask unanimous consent to suspend the order of the calendar and take up House Bill 1176 at this time.
1176. Think there's agreement on both sides. Senator from the 14th, what purpose you rise?
Proper time excuse Senator from voting.
Senator from the 33rd will be excused without objection.
Elsewhere in the building, on business.
I understand he's a busy man. Is there objection? Without objection, we will take the bill up at this time. Secretary will read House Bill 1176.
House Bill 1176 by Representative Golick of the 34th and others. A bill to be entitled and add to amend Chapter 1 of Title 15 and Title 16 of the OCGA relating to general provisions relative to courts and crimes and offenses, respectively, and for other purposes. Amendment number 1. Senator from the 30th offers the following amendment. To amend Chapter 7 to amend House Bill 1176 by replacing lines 1 through 5 with the following. To amend Chapter 7 of Title 5 of the OCGA relating to appeal or certiorari by the state in criminal cases and for their purposes. Amendment number 2, Senator from the 30th offers the following amendment. Amend the House Bill 1176 by revising lines 318 through 398 as follows. As used in this code section, the term dwelling means any building, structure, or portion thereof which is designed or intended for occupancy for residential use and for other purposes. Amendment number 3, Senator from the 30th offers the following amendment. Amend House Bill 1176 by deleting misdemeanor on line 414. Amendment number 4 by Senator from the 30th offers the following amendment. Amend House Bill 1176 by replacing including with other than on line 603 and for other purposes. Amendment number 5, Senator from the 30th offers the following amendment. Amend House Bill 1176 by replacing lines 713 through 716 with the following, reserved. Amendment number 6, Senator from the 54th offers the following amendment. Amend House Bill 1176 by inserting between lines 1078 and 1079 the following. Trafficking a person for sexual servitude as defined in Code Section 16546 and for other purposes. Amendment number 7, Senator from the 54th offers the following amendment. Amend House Bill 1176 by replacing C and G with CE and G on lines 1161 and for other purposes. Amendment number 8, Senator from the 39th offers the following amendment. Amend House Bill 1176 by replacing $1,000 with $600 on line 266.
Chair recognizes Senator from the 30th present the bill.
Thank you, Mr. President. House Bill 1176 is the result of an effort that started in this body and in the House last session with House Bill 265, which created the Special Counsel on Criminal Justice Reform. There was a structure set in place by legislation that we passed to have a council established to look at the cost in our prison system that had grown to over $1 billion, to look at the reasons for that cost and to find out whether we could more efficiently spend those dollars and at the same time increase public safety in the state of Georgia. The council met several times over the summer, was made up of a diverse group of people involved in the criminal justice system. We had experts analyze data and gather information about what was driving the increases in our prison population in this state, and basically came to some bottom line conclusions. One being that if we made some policy changes, we could save an anticipated $264 million over the next 5 years, and we could do it by increasing public safety. And the way to get there is to focus on property offenses and low-level drug offenders who are increasingly being placed in jail and who have the ability to take advantage of other opportunities in the state, such as drug courts and mental health courts, which we believe will keep them out of the prisons. So in order to improve public safety, we have adopted some of the council's recommendations in House Bill 1176, and I'd like to run through some of those at this point. Some of the major areas we address in the legislation is to set standards for our drug courts and mental health courts in the state. We currently have drug courts and mental health courts operating, but there are not necessarily any standards that are statewide. So with the governor's recommendation that we put $10 million in the budget for these courts, we want to enact some standards for how they will be run and certified, and how the performance will be measured of those courts. We also looked at the burglary statute in Georgia, which was a driver of our prison population. That statute currently only has 1 degree of burglary. We decided that there are more serious burglaries if, for example, if you enter into somebody's home, which in the law is called dwelling, that is a more serious offense than if you burglarize a shed that is empty in the backyard, or a vacant building where nobody resides. So we created 2 degrees of burglary. Entering a dwelling would be the more serious, and the other would be a 2nd degree. We also address the issue of the drug users versus the drug sellers by creating weight-based drug prosecution, which means that we currently have drug possession charges for anyone who has from 4 grams to 28 grams in their possession, or excuse me, from 0 grams to 28 grams. And it's all in the same category. And one of the recommendations was that we break out categories, so a person who has less drugs in their possession would be treated differently than a person who has, for example, 28 grams. And at 28 grams, you're getting to the level of drug selling and drug trafficking, and we believe that will be an improvement and will help us with the prison population. There are also several things that we can do for people who are in the prison system to try to get them rehabilitated and back as productive tax-paying citizens in the probation system. There are provisions in the bill that would set up graduated sanctions for probationers that would allow probation officers to enact sanctions short of returning the person to jail, so to keep the person out of jail, but also keep them on the right track by what are called graduated sanctions. There are a couple of provisions in the bill that that came from Senate bills that we have already passed. Senate Bill 316, which eliminates the statute of limitation for certain child sexual offenses, is part of this legislation. Senate Bill 355, which expands the mandatory reporters for child abuse, is also included in this legislation. There are some other provisions that resulted from some House bills that had been debated over the last session. One is the issue of record restriction. There's a big issue of people who have had involvement with the criminal justice system, maybe been arrested but not prosecuted, or been arrested and not finally found convicted, who have to deal with that on their record for the rest of their life, basically. So we have some provisions in the bill that would allow for those records to be restricted if a person is applying for a job, but not restricted to the extent that law enforcement or judicial officials would not get that information. There are also some provisions that we believe will help counties with funding of drug courts. we have currently what are called DATE funds, drug education and treatment funds that we have added the list of offenses that those can be charged for, which is a 50% add-on to the fine. So that will hopefully bring in some more money for the local counties to have drug courts if they wish, and they don't have them now. We also have probation detention centers that were set up to be short-term places for probationers so that they could continue working and check in and serve their sentence that are, we need to place a cap on, so we're placing a cap of 180 days on the probation detention centers so they're not overutilized, and we believe that'll help the counties also. Mr. President, there are several amendments, and I'll run down those amendments real quick, and then Senator from the 54th has a couple of amendments to the bill that was his legislation and the mandatory reporting bill. The First Amendment deals with, there's been some concern that because we are making some of the crimes will be misdemeanors as opposed to felonies, such as thefts and shoplifting, because we're changing the threshold for a felony. Currently, shoplifting is a felony if it's over $300, and we're making it $500. A lot of our theft offenses are a felony at $500, and we're taking those to $1,500. So there is some concern that there will be more cases in state court, and so we are, in Amendment Number 1, we're allowing for the state court to appeal on motions for new trial that are denied, or excuse me, that are granted, and they ask for that to help with what they believe may be an increased caseload. The Second Amendment is the Senate version of the burglary statute. The House separated burglary into 3 degrees, and we, after consultation with prosecutors, we believe it was a little too complicated, so we've narrowed it down to 2. And I basically described the amendment when I described the burglary provision. The Third Amendment is just to clarify one of the provisions in the bill about recidivism and make sure that when a person is convicted for a misdemeanor, that is counted when you're trying to determine the number of convictions. Amendment Number 4 clarifies. We had a lot of discussion about forgery, and we've made some changes to our forgery statute and separated out checks. Checks evidently are the most common type forgery, forged checks, and there are other writings that are forgeries and in the current law. So in this provision, we're separating out the crime of check forgery and creating, similar to the other provisions on the threshold for felonies, we create some thresholds for felonies in forging checks, and the threshold would be $1,500 or more would be a felony, or possessing 10 or more blank checks. We also had a lot of discussion about how to deal with a person who possesses a blank check that is intended to be passed, and the forgery would occur but hadn't occurred yet. So the misdemeanor forgery would be less than $1,500. Amendment Number 5 basically corrects another recidivism issue in terms of how we treat weight-based recidivist. When to back up a little bit, we're also pushing out the weight-based implementation so that our crime lab and prosecutors can get prepared to handle those types analysis. And one of the things we did in that process was set up the punishment in different ways based on the weight of the drug, and we were addressing the recidivism, and this corrects what needs to be corrected in the way the bill came over from the House. If there are no questions, Mr. President, I will yield the well.
Chair recognizes 739th for a question.
Will the senator yield?
I yield.
Is it not true that I'm going to vote for this bill?
That would be a good vote.
Would be
Senator.
You say it would be a wise thing to do.
I believe it would.
Will senator further yield?
I do.
Is it not true that presently an offender pays $300 as a fee or payment to the drug court?
I'm sure there is a fee involved. I don't know if it's the same in every county in the state, but I'm sure there is a fee.
And isn't it true that this bill would raise that fee from $300 to $1,000?
Well, the bill raises a fee from $300 to $1,000, but it's for I don't know if it's for drug courts. I think it's for a diversion program, which I guess could be considered drug court, but the way it is in the statute is for diversion programs.
Will the senator further yield?
Yes.
If that is indeed the case, wouldn't that increase from $300 to $1,000 for either the drug court or, as you say, the diversion program? Would it not? Isn't it true that because of the kind of offender that we're working with at the drug court, that it might be more likely that they would not be able to pay a $1,000 fee? Is that not correct?
Well, there's a provision in the legislation that allows that fee to be paid in partial payments, so I'm sure the court would work with the person to make sure the fee is paid. I don't think the intent would be to not have that, be able to work that out.
Will the senator further yield?
Yes.
I appreciate that very, very much. But isn't it true that you'd more likely to be defeating the purpose of the drug court or diversion program by virtue of the fact that if a person is not able to pay that large fee of $1,000, being the kind of offender we're talking about, being oftentimes dependent on drugs and other things, that offender might be more inclined to go back to jail and defeat the whole purpose of the diversion program?
Well, I believe the purpose of the program is for the judges to work very closely with the offenders that are in drug court. I think it's safe to say that they're going to do everything they can to keep them in the program, and they obviously, judges should be commended that are conducting these drug courts, because I'm sure it takes a lot more work than otherwise they would have to do, and is very intensive. And so I don't think they're going to let a person who obviously they care about helping not be able to participate for that reason.
Thank you.
Chair recognizes Senator from 42nd for a question.
Will the senator yield?
I yield.
Is it not true that you have vast amount of bipartisan support for this bill, and it's
I believe that's true. Thank you.
I have a specific question about some of the things that the senator was just asking you about. Do you have a copy of the bill?
I do.
I'm looking at line 268, 267, and 268. And that's the section that you were just discussing about diversion programs, and it indicates now that the fees for these programs can be waived in whole or in part, or be made payable in monthly increments upon a showing of good cause to the prosecuting attorney. And as I understood the discussion you were having about the court monitoring these, I was wondering if you would be amenable to ensuring that that showing of good cause would be made to the court rather than the prosecuting attorney.
Well, the prosecuting attorney is the one authorized to assess and collect the fee, and I'm assuming that's why the language is drafted as it is, and I'd be a little worried about what that amendment would do to the process and the intent of the legislation. But I believe a judge, again, would work with a prosecutor to try to make sure if this if this is a drug court fee, and I mean, I don't know, this is pretrial intervention and diversion, which certainly could qualify. And if that's the case, I do believe the judge is going to make every effort to make sure the person is able to participate.
Senator, you have one final question?
I do.
Do you know what the current practice is and whether you would apply for a waiver of this fee to the court or to the prosecuting attorney?
I don't see anything in the current law about a waiver process.
I'm sorry.
It looks like we're establishing a process where the fee may be waived or made payable in monthly increments upon a showing of good cause.
And I agree with that. And my question is, if you yield one final thing, these pretrial diversion programs are housed by the court, and under current practice, isn't it true that the court is the person that operates to ensure the payment plans, et cetera?
Yes, I would assume the judge and along with the prosecutor is administering the collection of the fees, and maybe the clerk of court is involved. Thank you.
No further questions, Senator.
Thank you, Mr. President. I urge your support of the bill and the amendments. The senator from the 54th will explain the last two amendments. Thank you.
The senator has spoken to his amendments, and Chair recognizes the senator from the 54th to speak to his.
Thank you, Mr. President. As I begin my remarks asking your support for Amendments 6 and 7, I want to thank the chairman of the Judiciary Committee, not just for his presentation today, but for his hard work on this very important bill for the future of Georgia. Above and beyond the call of duty, I don't think covers the time and effort and concentration and care he's put into this process. So I want to thank him for that. Amendment 6 really relates to an initiative that our body started that was adopted in this process. You will recall that earlier in this session, we passed a bill increasing the statute of limitations for sex crimes committed against minors. And in adopting this initiative, the House excluded an offense that we had added to the code as it was found in Georgia, and that was trafficking a person for sexual servitude. We're asking to include that in the list. I think that's appropriate, given that we're going after the same sort of offenses. Amendment number 7, again, is an initiative that started in the Senate independently. The senator from the 45th introduced a bill that got broad bipartisan support in terms of mandatory reporting. This is an intermediate position between what we passed in our body and what the House passed as part of the reform package. And this is language that's been negotiated to satisfy the parties involved. And if I could, before I leave the well, Mr. President, I do want to speak to Amendments 8 and 9 just briefly, because I really do think that the issue that's trying to be addressed here, and let's be honest, it's criminal justice, but there's also an economics piece to what we're doing. That is the case most times when we're talking about government, because we're talking about money. This allows for a fee to be higher when it's an appropriate thing to charge. I think that most counties, most prosecutors, most judges, but their incentive when they're going to keep somebody in a county jail, it's going to cost them money. So they're not going to let the fact that they get a lower fee or waive part of the fee or get it on an installment plan interfere with their ability to divert them from a higher cost position in our community to a lower cost and also better results outcomes. So I think that what it does is allow a prosecutor to recover a higher fee when someone is able to pay, but certainly it would be penny wise and pound foolish for them to insist on the higher fee and then it costs them money to incarcerate an individual. And with respect to Amendment number 9, I just don't think that's the posture that this was put forward. It's a pretty strong bill that's been negotiated by many parties, and so I would urge your support for Amendments 1 through 7 and your oppositions to Amendments 8 and 9. If there are no questions, Mr. President, I would yield to well.
No question, Senator.
Thank you, Mr. President.
Senator from the 39th is recognized to speak to Amendment 8.
Mr. President, members of the Senate, this is a very simple amendment. It would cap the fee charged to an offender in the pretrial intervention or diversion programs from $1,000. It would lower that cap to $600. Senator from the 54th makes a good point, but the fact of the matter is, while a judge would have discretion, the fact is that there are going to be some defendants who are going to be burdened so much so that they will not be able to pay the fees, particularly with the kind of offenders that we're talking about, who are oftentimes, if not most times, drug offenders. They will be in a situation where they will be going back to jail. And I agree with Senator from the 30th when he says that the intent of the prosecutor and the court is to do otherwise, but the fact of the matter is you're going to have some offenders in a position where they're not going to be able to pay a fee of up to $1,000 when it's applied, and they're going back to jail, which defeats the whole purpose of this bill. I'm voting for the bill. It doesn't go as far as I would like necessarily in transforming our criminal justice system, but it is a good first step, and making sure that offenders will be able to stay out of jail and become productive members of society, I think is a critical element. I think the amendment that I'm offering this afternoon helps to do that, and I commend it to you and ask for your favorable consideration. Mr. President, I yield well unless there are questions.
No question, Senator.
Thank you.
Chair recognizes the senator from the 42nd to speak to his amendment, amendment number 9. The senator from the 42nd.
Thank you, Mr. President. My amendment is very simple. On line 268, in addition to raising the fee for pretrial diversion programs, this amendment, the new language says that fee can be waived or changed at the discretion of the prosecuting attorney. That means that the person who's charging the fee also determines whether or not that fee should be waived. So it's all part of a plea bargaining process, rather than having the court be able to say this particular person should pay less or be allowed to pay less or waive certain aspects of the fee. It makes more sense to have the amount of the fee be subject to review by the court. That's the only thing it does, rather than the prosecuting attorney.
Okay, here we are. Is there objection to amendment number 1, which is authored by the senator from the 30th? 9 and 10. I'm sorry. We need to read amendment 9 and amendment 10. Who offered amendment 10? Okay. Go ahead.
Amendment number 9, Senator Carter from the 41st offers the following amendment to House Bill 1176, striking prosecuting attorney on line 268 and replacing it with court. Amendment number 10, Senator Jones from the 10th offers the following amendment to House Bill 1176, replacing on line 1557 if he or she agrees to record restrictions with the following, if it meets the requirements for restrictions set forth in this code section.
Senator from the 10th, I did not give you the opportunity to speak to your amendment. You're recognized to do so.
Thank you, Mr. President. And let me just kind of state for the record that I strongly support the senator from the 30th as well in his efforts in bringing this bill to the floor. And let me also give my applause and recognition to the governor, who 2 years ago first stated in the State of the State that Georgia could not continue to afford this high rate of incarceration. And I, along with the senator from the 41st, had an opportunity to speak with the governor a few days ago about this particular issue, by the way. And let me just say that we're very, very supportive of the initiatives that the governor has laid out. And it's my hope that not only can we pass this unanimously, but also look towards some of the remaining issues that in the future may need to be addressed. And certainly when you think about accountability courts, one court that comes to mind is traffic courts. And it's my hope that at least we can move in that direction, certainly at some time in the future. But I stand in support of this legislation. I also stand in support of Amendment number 10 to House Bill 1176. And basically what this amendment attempts to do is to change line 1557 of the bill, and I've had some ongoing discussions with the chairman of the Judiciary Committee, by the way, regarding this particular change. And one thing that I said to him is that I did not want to do anything that he did not see as being favorable to this particular bill. But what this amendment simply does on line 1557 is that it changes that particular line where it says he or she agrees to record restriction with the following, that if the requirements for restriction set forth in this code section is satisfied. And I believe that the changes in Amendment number 10 will strengthen the bill and certainly not make it worse than what current law is. And there are some concerns that the way the language reads in the expungement section, section 6 of this particular bill, that what we put in here is worse than what current law is. This change, Amendment 10, will certainly make it consistent, and I'm going to defer to the senator from the 30th as he consider my amendment. Thank you, Mr. President. I yield the well unless there are questions. Thank you.
All right. Chair recognizes the senator from the 16th for a motion after he gets done with his BlackBerry.
Thank you, Mr. President. I ask unanimous consent to be excused based pursuant to Senate Rule 5-1-8D.
Without objection, the senator will be excused on the conflict ruling. Questions on the adoption of Amendment number 1 authored by the senator from the 30th. Is there objection? Without objection, Amendment number 1 is adopted. Now the question is on Amendment number 2 authored by the senator from the 30th. Is there objection? Without objection, Amendment number 2 will be adopted. Question now is on Amendment number 3, authored by the senator from the 30th. Is there objection? Without objection, Amendment number 3 is adopted. Question now is on Amendment number 4, authored by the senator from the 30th. Is there objection? Without objection, Amendment number 4 is adopted. Question now is on adoption of Amendment number 5. Is there objection? Without objection, Amendment number 5 is adopted. Question now is on Amendment number 6, authored by the senator from the 54th. Is there objection? Without objection, the Amendment number 6 is adopted. Now that takes us to Amendment 7, authored by the senator from the 54th again. Is there objection? Without objection, Amendment number 7 is adopted. Is that another one? Now we move to Amendment number 8, authored by the senator from the 39th. Is there objection? There is objection. I don't understand it either, Senator. Senator from 39th, what purpose do you rise?
I'm going to move for the yeas and nays.
Move for the ayes and nays. All of those in favor of amendment number 8 will vote aye. Those opposed, no, and the secretary will unlock the machine. On the amendment authored by the Senator from the 39th, amendment number 8, the yeas are 18 and the nays are 32, and amendment number 8 is lost. Now this takes us to amendment number 9, authored by the Senator from the 42nd. Is there objection? There is objection to amendment number 9. Chair recognizes Senator from the 42nd. What purpose do you rise?
Mr. President, I would ask unanimous consent to withdraw amendment number 9.
Senator from the 42nd is going to withdraw number 9. Is there objection? Without objection, it will be withdrawn. Now the question is on amendment number 10, authored by the Senator from the 10th. Is there objection? There is objection. Chair recognizes the Senator from the 10th. What purpose do you rise?
Mr. President, I ask unanimous consent to withdraw amendment number 10.
Without objection, the Senator withdraws amendment number 10. Amendment number 11, authored by the Senator from the 6th, is before you. Secretary will read.
Senator from the 6th offers the following amendment. Amend House Bill 1176 by replacing the word any with the first degree on lines 1904 and 1906.
Chair recognizes Senator from the 6th to explain his amendment.
Thank you, Mr. President. What amendment number 11 does, it deals specifically with juveniles. And the concern is that some of us sometimes make mistakes when we're a little bit younger. And this has to do with burglary in the sense of if you break in some residential or shed or something, and what we're looking at here is where someone makes a mistake young in life, we don't end up trying them as an adult right off the bat. So what this would do is require that basically if you, for the 4th time you've broken into a residence, no matter what you're doing, you're going to be automatically transferred and it would apply to, in the sense you would move to be tried as an adult. And the thing here is trying to make sure we don't automatically run folks off, put them on burglary charges as a juvenile right off the bat into adult court. And this is what this would do. It would basically say you do this a 4th time, in the sense of a residence, you're going to be tried as an adult. And that's all this does is a change in the bill. Now, I would ask for your consideration for this amendment. If you have any questions, I'd be happy to answer that. Mr. President, otherwise I yield well.
Chair recognizes Senator from the 2nd has a question.
Gentleman will, do you yield?
I yield.
What if you were arrested in another state as a juvenile 3 times and you come in Georgia and you do a burglary? Now, are you tried as an adult?
My understanding is that this is only applying to what's going on here in this state, in the sense what you could not use what happened in a previous state.
Does the senator yield? Did you
I
say
yield.
you can't use what you've done in a previous state?
Most likely you wouldn't be able to use that in a court. Now, I'm not a lawyer on that issue, but that's my understanding you couldn't.
Wouldn't that encourage prospective criminals to come to Georgia if they've been...
Well, I don't know many 16-year-olds who are traveling gangs, or 14-year-olds or 15-year-olds. Now, if you're a 17-year-old, it's a different story. So,
Does the senator further yield?
I yield.
Isn't it true, Senator, that cities that border states, the neighboring states are encouraging their parents to either move or the next time their kid will be tried as an adult in neighboring states?
Well, Senator, that could be a case, but obviously I assume we have some discretion in that. But on this issue, I could see, particularly where I live, where some kids can make some mistakes. I mean, I think some of us remember some things back in the 1960s. I know this for a fact. Folks steal hubcaps, do some stupid things, and they used to get the choice either go to jail or go to Vietnam. And kids do stupid things sometimes when they're young. Well, this is to make sure, but if you do it again, do it several times, you're going to be tried as an adult automatically. There's no question at that point.
All right, thank you, Senator.
Thank you.
Chair recognizes the senator from the 25th for a question.
I yield.
Thank you, Mr. President. Senator yields?
Yes.
I understand what you're trying to do, I believe, but you are saying that this would only apply if a juvenile broke into a residence, which is burglary by the first degree.
Correct. And that's what it applies to fourth burglary and first degree is what this would apply to.
So burglary by the second degree also includes commercial establishments, businesses, factories,
Right.
a number of other
This
things.
would not apply to that. I'm just saying
that may be a policy decision for us all to decide whether that residency would be the only thing that it would apply to, because breaking into a business is a pretty serious thing.
Well, but I think on that point is that if you're in the sense this is burglary in first degree applying to residents, probably if you're breaking into commercial, that it's very possible you could be tried as an adult in that situation.
Thank you.
You're welcome.
No more
Okay.
questions.
Thank
sir.
you, Mr. President.
Questions on amendment number 11, authored by the senator from the 6th. Is there objection? There is objection. All those in favor, rise, stand to be counted. If you are in favor of amendment number 6, rise, stand to be counted. Are you in favor? This is number 11. Reverse. On amendment number 11, authored by the senator from the 6th, the yeas are 12, the nays are 26, and the amendment has lost. No committee substitute. No committee substitute. Does any other senator wish to speak for or against the bill? Is there objection? Agree in the Porter Committee which fail pass the bill. Chairs none. Porter Committee is agreed to. Shall the main question be now put, or are there any objections? Chairs none. The main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 51 and the nays are 0. This bill, AMC Rex Constitutional Majority, is therefore passed. Chair recognizes Senator from the 19th.
Mr. President, I move that the Senate insist on its substitute to House Bill 954.
Read the caption.
House Bill 954 by Representative McKillop of the 115th and others. A bill to be entitled Now to amend Article 5 of Chapter 12 of Title 16 of the OCGA relating to abortion so as to change certain provisions relating to criminal abortion and for other purposes.
The senator has moved that the Senate, read the cap, did we read the cap? Move that the Senate insist on its substitute to 954. Is there objection? Without objection, the Senate has insisted upon its position. Secretary will read House Bill 899.
House Bill 899, by Representative Brockway, the 101st and others. A bill to be entitled now to amend Chapter 2, Title 21 of the OCGA relating to primaries and elections generally so as to provide for the dates of nonpartisan elections and for other purposes. The Senate Committee on Ethics recommends that this bill do pass by substitute. Senate Rules Committee offers the following substitute to House Bill 899. A bill to be entitled an act to amend Chapter 2, Title 21 of the OCGA relating to primaries and elections generally so as to provide for the dates of nonpartisan elections and for other purposes.
Chair recognizes the senator on the 54th.
Thank you, Mr. President. Thank you, members of the Senate, for the opportunity to present House Bill 899. House Bill 899 deals primarily with the functions of the Secretary of State. The biggest portion of this bill is the general cleanup that we see every year to our elections code. There are three other things that are more or less covered by this bill. One is that it authorizes online voter registration. Another is that it addresses a qualification extension period where an incumbent qualifies and then withdraws during qualifying for office. And the fourth thing is that it brings all nonpartisan municipal elections into the same voting schedule. Real quick, wanted to address the issue on the online voter registration. There had been some question about when that would go into effect. Wanted to make sure that the members understand that this is an authorization. The Secretary of State's office now will have to embark on implementation. There is no deadline or set schedule for that. There is no expectation that this would be available this year, so nobody needs to run out and jump on the computer and try and register in the near term. They're going to have to go out for bids and make sure they're ready to do this. Mr. President, I do have notes on a section-by-section basis, but in the interest of respecting the Senate's time, I would yield for questions, and if there are none, I'd ask favorable consideration.
No questions, Senator.
Thank you, Mr. President. I ask your favorable consideration. I yield the well.
Chair recognizes Senator 22nd. Speak to the bill.
Thank you, Mr. President. Members of the Senate, I want to speak briefly on this measure. We've taken a very good bill, a bill that I helped work on over this past summer, along with the senator from the 18th, Senator Staten, as part of the Elections Advisory Council. And I want to point out just a few things that takes this from being a great bill to a very poor bill. In the preamble, lines 28 and 29, and then in section 9, lines 428 through 432, there was an attempt to move what formerly was House Bill 776 into this measure, thereby making it a very terrible bill. What this is in an attempt to circumvent the local charter of the city of Augusta and move our elections from November to July, essentially usurping the authority of a local act that we have that governs not only our elections but our form of government. And if there are no questions, Mr. President, I yield the will. I'm going to be voting against this measure.
No questions, Senator. Chair recognizes Senator 29th.
Thank you, Mr. President. I, too, like the senator from the 22nd, served on the committee that considered the original bill, which I think was a good piece of legislation that incorporated many of the aspects of the advisory council's report. Unfortunately, there has been added to this bill language involving a proposal to alter qualifying so that if an incumbent qualifies and then withdraws, qualifying is reopened. I know, having spoken to my local elections folks that they don't want this. It is essentially an unfunded mandate on them. I think it's unfortunate that that was added to this bill. That's why I voted against engrossment. And I think we should have just kept this to the items the Secretary of State's office wanted and not include these superfluous provisions. So I'll be also voting against it. Thank you, Mr. President. I yield the will.
The question is on the adoption of committee substitute. Is there objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection agreed to report of committee which fail will pass the bill? Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes Senator 22nd.
Thank you, Mr. President. Mr. President, is it not true that this bill, which was a great bill, has been turned into a bad bill, as noted by the senator from the 29th and the 22nd?
I know the senator has great passion on this issue. Great passion. On the pass of the bill, the yeas are 23, the nays are 19, and the bill has failed. Secretary will read House Bill 899. I'm sorry, House Bill 924. '23. What purpose you rise, Senator? State your inquiry.
Is it appropriate for a motion for reconsider or notice for a motion for reconsideration to be made at this point?
No, not at this time. Already moved on to other business. I called. Yeah. I already moved on to other business, but it would go to the general calendar, which basically, I mean, it's dead. Secretary will read
House Bill
923.
House Bill 923 by Representative Howard of the 121st and others. Bill to be entitled an act to amend an act providing for the consolidation of Richmond County and the City of Augusta, approved March 27, 1995, as amended particularly by an act approved April 8, 2002, and for other purposes. The Senate Committee on Reapportionment and Redistricting recommends that this bill do pass by substitute. The Senate Reapportionment and Redistricting Committee offers the following substitute to House Bill 923. Bill to be entitled an act to amend an act providing for the consolidation of Richmond County and the City of Augusta, approved March 27, 1995, and for other purposes.
Chair recognizes Senator from the 23rd.
Thank you, Mr. President. I rise in support of the Senate Committee substitute to HB 923. This is a companion bill with HB 924. They both deal with Richmond County Board of Education and the Augusta Commission Consolidated Government. The two maps that were voted out 5-2 out of reapportionment, both are identical in the drawing of the districts for Richmond County Board of Education and the Augusta Commission. 923 deals with the Commission. An advisory committee made recommendations in this matter. However, the targets set by the advisory committee for a swing district were not met. Consequently, the Commission was deadlocked and there was a strong dissent on the Board of Education. a number of local officials asked that the Legislative Reapportionment Office assist them in coming up with an alternative plan. An alternative was drafted, which was ultimately endorsed by all the dissenters on the board and by an effective majority on the commission, which also included a request by the mayor of Augusta that the Senate approve the alternative. The alternative was a compromise which hit the targets which had been missed by the advisory committee. This alternative compromise offered was more reflective of the demographics of the community in the swing district. This alternative being presented today will avoid the costs, delay, and uncertainty that would be otherwise entailed by not adopting any maps. It is the universal desire of the constituents in Richmond County to avoid sending the Augusta-Richmond County maps to the courts for decision. Accordingly, I urge you to support Senate substitute for HB 923. Thank you. If there are no further questions, I'll yield the well.
There is a question, Senator. Chair recognizes Senator from 22nd. Do you have a question? No. No question,
Okay.
Senator.
Thank you.
Chair recognizes Senator from 22nd. Speak to the bill.
Thank you, Mr. President. Mr. President, members of the Senate, I rise this afternoon with an abundance of caution. I rise not only with an abundance of caution, but with an understanding that at any moment, at any time, this could be my last opportunity to stand in this distinguished chamber, and it could also be my last opportunity to represent the good citizens of Augusta, Georgia. And I rise to speak in opposition to House Bill 923 by substitute, and then in a few moments, House Bill 924 by way of substitute as well. On the screen, I want to take an opportunity to walk you through what I've had to deal with over the last several months. It has been brought to my attention, and I want to take a moment this afternoon to invoke the legacy of the late and distinguished Senator, the Honorable Robert Brown. And I want to indulge you for a few moments. I don't have the tenacity or the fervor that a Robert Brown does, but I do believe that I can articulate my position. It has been said to me that there was a concern by members of my community that I've had the great fortune of representing for the past 6 years, that they needed to send some folks down here this year to save Augusta. To save Augusta. On the screen, I want to walk you through a couple of slides. They're very simple slides, but when I thought about that, when I thought about this whole notion of saving Augusta, the thing that struck me as odd was I live in Augusta. And here on these slides, just if you'll indulge me for a few minutes. Okay. I'm going to let them bring that back up. And if I flick it. But I heard this notion about taking back, saving Augusta. It reminded me of this notion about taking back our country. The grassroots America, we the people, learn how to take back our country. I then found another slide that I thought was real interesting. That this whole notion of taking back our country, it reminded me so much of what I had heard about saving Augusta. I've been there for over 25 years, and I don't know about what it needs to be saved from, but at any rate, I've got a couple of slides, and this last one, I want you to remember this. In a couple of days, y'all are going to come to Augusta and spend some time down there with us, and many of you are going to come to this wonderful little golf course called Augusta National. But let me share this with you. Our local maps, the map that the senator from the 23rd proposed a substitute to, it was done in such a way that not only did it silence the voice of so many members of our community, but it took great effort to not only further polarize our community, but divide our community. I spent the last 6 years working across the aisles, helping folks on both sides, being able to be called almost on a 24/7 notice by members throughout our community, Republican, Democrat, black, white, didn't matter, because they elected me to be their representative for this great community. And so when I heard this notion that some folks were sent down here to save Augusta, it took me back to some things that I had written down, and let me just share the following with you. We ain't got nothing but time on our hands anyway. And here's what I remain confused by this term: take back our country, save Augusta. What happened and what turned into this notion of disagreeing? I think it happened late one night when we began as individuals to join packs and to decide my way or the highway. Had the same ring to it as the Bill of Rights or self-chosen phrases from a holy book that we call the Bible. Why am I confused this afternoon? Well, partly because in the life of any citizen, surely we've all lived with a senator, a representative, or even a president that we did not like. We knew those officials were coming up for an election in a short period of time. Time to gather one's commitment and begin to listen and learn as the newly elected went forward. Time to see if there was more than you could see at first. Well, as I hear this call to save Augusta, just like they render take back our country, what I sense is a fear. It's not enough to be duly elected, apparently, because we spend time rewriting the rules. I spent 3.5 months working with citizens throughout Augusta, developing the local maps that were approved, voted on unanimously, and subsequently sent to this legislature. In fact, it was a historic moment in Augusta. From the time that we started this work in September until we completed this work on November the 29th of 2011, we represented the voices of those citizens of Augusta, Richmond County. 12 individuals, 4 members from the school board, 4 members from the commission, 4 members from the legislative delegation, who voted unanimously to send maps to this body that we might in fact move forward. They voted their conscience. They voted in a manner that was consistent with the wishes of the community as we had one public hearing after the other. We had public hearings all across Augusta, Richmond County, in every segment, in every corner of the community. But we've come to a place of where folks have been sent here to save Augusta. We've got that slogan in Augusta, save Augusta. And I'm still struggling with it, a phrase coined by businessmen, boardmen, dissenters, citizens, and Copenhavers. The only problem I have with this phrase is the question of from whom or from what shall Augusta be saved? In fact, I'm so disturbed by this statement because I seemingly did not get the memo that my beloved city needed to be saved. I can think of some folks who need to be saved. In fact, I can think of some folks who might need a Damascus Road experience like the Apostle Paul. You remember the Apostle Paul? He saw the light while being knocked off of his beast. And when he came to his senses, he began to see through the eyes of God. And he realized that all Gentiles were in need of a Savior. So I still don't know what we need to save Augusta from. The last time I checked, people from all ethnic backgrounds lived, worked, played, and raised children in Augusta. And it's unfortunate that we find ourselves in Augusta, Richmond County, one of the finest cities in this great state. In fact, the second largest city in this great state. A state that the senator from the 24th not only has a business in, but he was born down the street from where I live now. A city that he too represents. A city that the senator from the 24th honors and represents, as he has for many, many years. And my good friend, who will be joining our delegation next year. In fact, senator from the 24th gave me a ride home a week ago. We had a wonderful conversation on the way back to Augusta. He's the same senator who has said that he is my friend. And so this afternoon we have before us two measures, House Bill 924, House Bill 923. Two measures that were engineered and manufactured, not with the people of Augusta, Richmond County at the forefront of that conversation, but independent of the wishes of the greater community. In fact, in a meeting in January of this year, there was a senator from our community and three others. I'll call them the dissenters. In fact, I didn't coin that term, but that term was given to me by the senator from the 23rd. He coined that term and declared that they were dissenters. And so we find ourselves at this juncture, at this great juncture in our community of where we've been pitted one against another. When in fact, I suggested to the senator from the 23rd that he and I not get in this business of dividing our city, polarizing our city, but rather we let the courts do it. That he and I might find common ground. That he and I might find ourselves at a place of where we do no great harm or great injury to our community. Now, I understand that's a risky proposition, but it's one that, had he and I taken that proposition, would have kept he and I both out of harm's way. That would have kept he and I both out of harm's way from either community. I'll tell you what we need right now. Instead of moving forward with this substitute, whether it's House Bill 923 or 924, legislation that unfortunately drew out one of the school board members from District 4 in a rush to judgment and in a haste to put something in place in an attempt to protect some incumbents but not protect all of them. They drew out the distinguished school board member, Barbara Pulliam, from South Augusta. Now, I don't know what that was all about, but they drew her out of her district. She happens to be an African-American female, drawn out of her district, and she probably didn't want that to happen. But I'll tell you what we need. I know what we need. We need to move beyond bad decisions by a few misguided folks who only see through the lens of a person's skin color while couching it as there's only one color called green. We need a cooling off period between elections. We need a cooling off period from this legislative session where cooler heads can prevail and we can do no further harm or damage to our community, our beloved community, Augusta, Richmond County. And so I want to pause here for a moment. I love Augusta. In fact, I love the great state of Georgia. I even love my distinguished colleague from the 23rd. I've enjoyed serving with him. And let me say this. We live in a variety of neighborhoods. We live with people of other faiths, color, and politics because we all know we have to. And I think in our hearts, we also want to. There's plenty of room for us to discuss the merits of how many districts should be drawn for any particular demographic. That doesn't concern me. What does concern me is that we do no further harm to Augusta, Richmond County. We have an opportunity to bring our community together, and we need to seize that opportunity and seize that moment and do no further harm to Augusta. By moving forward with these proposals, these two maps, we will do great injury and great harm to our community. There's plenty of room for us to discuss how to downsize or grow government, how to trim the budget, whether to build ball fields or biotech parks. There's plenty of room for working together in communities such as Augusta. But it requires that people move away from a position of fear when redistricting maps are drawn for commission and school board members. And so, with that, Mr. President, I leave you with this. To he who is given much, he or she must do much. To he who demands much, he or she must give much. And for those of us that make up this great body, I believe it is incumbent of us to serve all of the people of our community, not just the select few, through backroom deals and the old boss system of politics. And if there are no questions, Mr. President, I'll yield the wheel.
No questions, Senator. Questions on the adoption of committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Grant report of committee which fair will pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Questions on the pass the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary unlock the machine. On the pass the bill, the yeas are 33 and the nays are 16, and the bill has passed. Secretary will read House Bill 924.
House Bill 924, Representative Howard of the 121st and others. Bill to be entitled an act to amend an act regulating public instruction for the County of Richmond, approved August 23rd, 1872, as amended particularly by an act approved April 28th, 2002, and for other purposes. Senate Committee on Reapportionment and Redistricting recommends that this bill do pass by substitute. Senate Reapportionment and Redistricting Committee offers the following substitute to House Bill 924. Bill to be entitled an act to amend an act regulating public instruction for the County of Richmond, approved August 23rd, 1872, and for other purposes.
Chair recognizes Senator 23rd. Speak to the bill. Present the bill.
Thank you, Mr. President. This is the companion bill that we just voted previously. This goes with 923. This is the bill on the Board of Education districts. I need to repeat that the people of Augusta want maps drawn, and we have done everything we can to do that and to incorporate input into this map process. We have the mayor of Augusta, along with a majority effective of the commission. We have all the people that refused to vote for the maps before are on board with these maps. These are good maps. They reflect the demographics of Augusta, and they are the maps that Augusta wants, rather than letting the federal courts decide, throwing incumbents into districts with each other. This is the right vote to take at this time, and I urge your passage of the Senate substitute to House Bill 924. Thank you.
Chair recognizes Senator from the 22nd to speak to the bill.
Thank you, Mr. President, members of the Senate. I want to share a short story with you. It reminds me of, as I said earlier, my last 2 months in this chamber, my last 2 months serving as an elected official from Augusta, Richmond County. It's been very painful. It's been very painful because as I have tried to be the voice of reason in our community, being pulled on both sides by my constituents, Republican and Democrat, black and white, all alike, who have found reason to reach out to the senator from the 22nd. I'm going to share a short story because as I think about this short story, I think about me. And I think about not only the decisions I've made, but more importantly, the things that I've left undone, primarily not listening to the person of the Holy Spirit to lead me and guide me and making head decisions instead of making decisions of being led by the Holy Spirit. And the short story says, there once lived a crow. One day he was very hungry. He had not been able to get any food the previous day. If I did not get anything to eat, I'll starve to death, he thought. As the crow was searching for food, his eyes fell on a piece of bread. He quickly swooped down, picked it up, and flew off. Far away in a lonely place, he sat on a tree to enjoy that bread. Just then, a hungry fox saw the crow sitting on the tree, holding the bread in his mouth. Yummy, that bread looks delicious. What I would give to get that piece of bread, the fox thought. The fox decided to use all his cunning means to get the piece of bread from the mouth of the crow. He sat under the tree. The crow saw him and thought, I guess this fox wants to eat my bread. I shall hold it carefully. And he held on to the bread even more tightly. The clever fox spoke to the crow politely. He said, hello, friend, how are you? But the crow did not say anything. Crows are such lovely birds, and you're very charming too, said the fox, flattering the crow. Then the fox said, I have heard that besides being beautiful, you also have a sweet voice. Please sing a song for me. By now, the crow started to believe what the fox was saying. The fox knows true beauty. I must be the most beautiful bird in this whole world. I will sing him a song, thought the crow. As soon as the foolish crow opened his mouth to sing, the bread fell from its beak into the ground. The clever fox, which had just been waiting for this very moment, caught the bread in his mouth and gulped it down his throat. The crow had paid a heavy price for his foolishness. I'm that crow. I paid a heavy price for my foolishness of not listening to the person of the Holy Spirit, making decisions and doing things based on head knowledge instead of understanding what the person of the Holy Spirit would have me do concerning these matters. I agree with the senator from the 23rd. The citizens of Augusta, they do want maps. They want maps that reflect the community in which we live in. I couldn't agree with him more. I also agree with the senator from the 23rd and that this ad hoc committee that was formed, though they have no statutory legislative power, but rather the same group of citizens, 7 blacks, 5 whites, from disparate sections of the community, came together over a 3-month period of time and consciously and discreetly looked upon themselves and said, we've got to make decisions that reflect our community. After much deliberation and great work, after 3 maps were put together by these individuals who make up this great community, there was a decision made to move forward with a map that was subsequently sent to this General Assembly. That map was passed out of the House, moved to the Senate, and summarily disposed of. Why? Because in midstream, we have the ability to do what we want to do, when we want to do it, and how we want to do it. My mama told me that when I get to that point, I'm grown, and I can get out of her house. I'm not suggesting anyone get out of this house. But what I am suggesting is this. We have a responsibility to represent all of the constituents of our community. No one can tell you in Augusta, Richmond County that they can't call me, whether they're Republican or Democrat, black or white, Asian or Latino. My phone is the hot phone in Augusta. Why? Because I represent all of the people. I will continue to do that. And so, Mr. President, members of this great Senate, we have a map before us. A map that, unfortunately, the school board map, takes great occasion to draw out of her district the distinguished and honorable Barbara Pulliam, member of the school board, while others were protected, drawn out of her district. I would encourage us not to vote for this map. If there are no questions, Mr. President, I'll yield the wheel.
Question is on the adoption of committee substitute. Is there objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree in the report of committee which failed pass the bill? Chair hears none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the pass of the bill. All of those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the pass of the bill, the yeas are 33 and the nays are 17. Hey, Ben. And this bill, having received constitutional majority, is therefore passed. Chair recognizes Senator from the 20th.
President, I'd like to move House Bill 929 and House Bill 930 to the foot of the calendar.
Is there objection? Without objection, the two bills will rest at the foot of the calendar. House Bill, Secretary will read House Bill 965.
House Bill 965 by Representative Nyder, 126, and others. Bill to be entitled an act to amend Article 5, Chapter 7 of Title 48 of the OCGA relating to current income tax payments and for other purposes. Senate Committee on Finance recommends that this bill do pass by substitute. Senate Finance Committee offers the following substitute to House Bill 965. Bill to be entitled an act to amend Article 5 of Chapter 7 of Title 48 of the OCGA relating to current income tax payment and for other purposes.
Chair recognizes Senator on the 16th to present the bill.
Thank you, Mr. President. Ladies and gentlemen, I rise before you to present House Bill 965, which is another Department of Revenue bill. And what we're doing here, this bill was recommended by the Georgia Society of CPAs, passed the House 161 to nothing. And one of the things that this does is it delays the filing of an estimated return by fiduciaries for 2 years after the death of a deceased. And this has to do with CPAs who are dealing with estates and should be consumer friendly because of that issue. Also takes language from House Bill 967, which removes a provision that requires that businesses pay taxes for non-resident withholding in the calendar month after the month that the withholding takes place. And I can go into the details of these issues if you like, and I'm happy to answer any questions, Mr. President.
There are no questions, Senator.
Thank you. I yield the well.
Questions on the adoption of committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreed, report of committee which fail will pass the bill. Chair is none. Report of committee is agreed to. Shall the main question be now put? Any objections? Chair is none. Main question order. Shall this bill now pass? Question on the pass the bill. All those in favor, vote aye. Those opposed, no. Secretary unlock the machine. On the pass of the bill, the yeas are 51 and the nays are 0. This bill, having C-Rex constitutional majority, is therefore passed. Secretary will read House Bill 971.
House Bill 971 by Representative Hembry, the 67th, and others. Bill to be entitled an act to amend. A bill to be entitled an act to amend Chapter 9 of Title 34 of the OCGA relating to workers' compensation so as to change certain provisions relating to awards and benefits of workers' compensation and for other purposes. Senate Committee on Insurance and Labor recommends that this bill do pass by substitute. Senate Insurance and Labor Committee offers the following substitute to House Bill 971. Bill to be entitled an act to amend Chapter 9 of Title 34 of the OCGA relating to workers' compensation so as to change certain provisions relating to settlement agreements between parties and for other purposes. Amendment number 1, Senator from the 54th and others offer the following amendment. Amend the Senate Insurance and Labor Committee substitute to House Bill 971 by replacing lines 7 and 8 with the following. Provisions relating to compensation for loss of hearing caused by harmful noise to amend Code Section 369121 and Part 1 of Article 3 of Chapter 5 of Title 50 of the OCGA and for other purposes.
Chair recognizes the senator from the 54th to present the bill.
Thank you, Mr. President. Thank you, members of the Senate, for the opportunity to present House Bill 971. At the appropriate time, Mr. President, when I resume my seat, I'm going to ask to unanimous consent to withdraw Amendment number 1, which is on your desk, shouldn't be attached to this bill. This is from our Workers' Compensation Advisory Committee. Thank you. And it addresses 3 things. If you look through the sections, the first is that it allows the board to require a settlement agreement that takes care of Medicaid set-asides. That's something that is done in the practice and should be required, or else we have some tax problems down the road. And then the two other things it does in Section 4, it increases or updates our hearing loss standards to conform with current standards of normal hearing range. It also allows the board to waive certain fines related to delayed settlement awards, and it expands the board's authority to appoint a conservator when there's a minor or incompetent person and a settlement amount is less than $100,000. That current threshold is $50,000. Mr. President, if there are no questions, I would yield the well. If there are, I would try to answer.
No questions, Senator.
Thank you, Mr. President.
What purpose? Senator from the 54th rise.
President, I ask unanimous consent to withdraw amendment number 1.
To withdraw amendment number 1. Without objection, Senator has withdrawn amendment number 1. Question is on the adoption of committee substitute. Is there objection? Without objection, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreed. Report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question order. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those opposed no. Secretary will unlock the machine. On the passage of the bill, the yeas are 48, the nays are 0, and this bill, I'm sure, Rex Constitution majority is therefore passed. Secretary Reed, House Bill 972.
House Bill 972 by Representative Weldon III and others. Bill to be entitled an act to amend Chapter 34 of Title 43 of the OCGA relating to physicians, acupuncture, physician's assistants, cancer and glaucoma treatment, respiratory care, clinical perfusionists, and orthodontics, and other purposes. Senate Committee on Health and Human Services recommends that the bill be passed by substitute. Senate Health and Human Services Committee offers the following substitute to House Bill 972. Bill to be entitled now to amend Chapter 34 of Title 43 of the OCGA relating to physicians, acupuncture, physician's assistants, and for other purposes. Amendment number 1, Senator Carter of the 1st and others offers the following amendment. Amend the Senate Health and Human Services Committee substitute to House Bill 972 by replacing lines 147 through 154 with the following. The board may establish minimum standards of continuing medical education for all physicians owning a pain management clinic and for other purposes.
Chair recognizes Senator on the 1st to present the bill.
Thank you, Mr. President. Senators, I bring before you today House Bill 972. This is the Georgia Pain Management Clinic Act. Many of you are aware of the prescription drug abuse problem that we suffer in our state. Many of you are aware of what we refer to as the pill mills, of the rogue doctors who are running these clinics and who are working at these clinics that are doing nothing more than writing bogus prescriptions for prescription drugs. What we're doing in this bill is to put these pill mills under the jurisdiction of the Composite Medical Board. Currently, when we bust these pill mills or when we prosecute them, we can get to the doctors. We can prosecute the doctors, but what they do, they're owned by other people who are non-physicians. And they simply go out and hire other doctors and bring them back in. So we can't really close them down. By this bill, what we do is we require pain clinics to be owned by doctors. This way, whenever we go and we close down that clinic, we will essentially close down the doctor and in turn close down the clinic. This will go a long ways in helping us to control these pill mills and to drive these pill mills out of our society that is infesting our society. It will help us, it will help tremendously to get rid of them and get them out of our communities. Mr. President, I'll be glad to answer any questions. If not, I would ask for your favorable consideration of House Bill 972.
No questions, Senator.
Thank you, Mr. President.
The question is on the adoption of the floor amendment. Is there objection? Without objection, the floor amendment is adopted. The question now is on the adoption of committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection agreed and report of committee wish to fail pass the bill? Chair is none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chair is none. Main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On passage of the bill, the yeas are 49, the nays are 3, and this bill, after city records constitutional majority, is therefore passed. Secretary will read House Bill 987.
House Bill 987 by Representative Riley of the 50th and others. A bill to be entitled an act to amend Article 7 of Chapter 17 and Title 47 of the OCGA relating to miscellaneous provisions relative to the Peace Officers Annuity and Benefit Fund and for other purposes. Senate Committee on Retirement recommends that this bill do pass. There is a fiscal note attached to the bill.
Chair recognizes Senator from the 54th. Present the bill.
Thank you, Mr. President. Thank you, members of the Senate, for the opportunity to present House Bill 987. I'm pleased to see that the chamber looks a bit more populated than my last visit to the well. Senators, this bill is to our Peace Officer Retirement Fund, and what it does is requires a member of the fund to notify the fund whenever they are changed or moved to a position that would not qualify them to continue to participate. Current law does not place that duty on the individual, the member of the fund. This allows for better tracking. Mr. President, I would yield for questions. If there are none, I'd yield the will, asking for favorable consideration.
There are no questions, Senator.
Thank you, Mr. President.
Does any other senator wish to speak for or against the bill? Is the objection agreed and the report of committee which fail pass the bill? Chair is none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none. Main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On pass of the bill, the yeas are 48 and the nays are 0. This bill, I'm serious. Constitutional majority is therefore passed. Secretary will read House Bill 990.
House Bill 990 by Representative Jones of the 46th and others. Bill to be entitled an act to amend Chapter 31 of Title 36 of the OCGA relating to incorporation of municipal corporations so as to change certain provisions relating to municipal control over parks and fire stations and for other purposes. Senate Committee on State and Local Governmental Operations recommend that the bill do pass.
Chair recognizes Senator from 56. Present the bill.
Thank you, Mr. President, fellow senators. This is a small bill relating to areas of Fulton and DeKalb that became cities, and making sure that tax dollars are collected prior, if it was in that area, the city stayed there, and that if a park was a park before, it will in fact be a park again. This is a simple and straightforward bill. If there are no questions, Mr. President, I will yield the well.
Chair recognizes Senator 39th for a question.
Will the senator yield?
Yes, Senator.
There was, and I know in Fulton, and I remember in DeKalb as well, the taking or the purchasing by the municipalities of parks and fire stations. Is that not correct?
Yes. Could you hold the microphone a little closer, Senator? I'm having
Yes,
trouble
sir.
hearing you. Thank you.
Yeah. You say that is correct?
Could you repeat the question?
Is it not true that when the North Fulton cities were incorporated, that there was the purchasing by those cities of parks and parks and fire stations for a nominal fee? Is that not correct?
That is correct, Senator.
Okay. And is it, if the Senator will further yield?
Yes, Senator.
Is it not true that what you are doing now in part in this bill is not only taking the buildings, but also after the fact getting the fixtures and any other improvements on such property? Is that correct?
Well, Senator, I believe they have been there for some time, and I don't believe it to be an issue.
Will the Senator further yield?
Yes, Senator.
However long they've been there, you're getting them now by virtue of this legislation.
That is correct. These cities have been in place for over 5 years now.
Now, will the Senator further yield?
Yes, Senator.
At the time of these incorporations, was it not the sentiment of a great number of people that they should have been sold at fair market value as opposed to the nominal amount that these cities received? Is that not correct?
I believe, Senator, there were a lot of opinions back then, but I believe the proper opinion applied, which is those who live in those communities had paid that through their taxes, so it should stay and not be charged an additional sum because it had been paid by their taxes to begin with.
Yeah. Will the Senator further yield?
Yes, Senator.
I appreciate that. That was your opinion, and there were varying opinions on that. But this is just the residue, is it not, of the incorporation battles of a former day?
I believe this is just cleaning up some older items, but I appreciate your question, Senator.
All right. Thank you.
No further questions, Senator.
Thank you, Mr. President.
Senator from 39th, are you wishing to speak to the bill? Okay. Does any other senator wish to speak for or against the bill? Is there objection, agree, and report of committee which fail pass the bill? Chair hears none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. Main question is, shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 39, the nays are 10. This bill having C-Rex constitutional majority is therefore passed. Secretary will read House Bill 1024.
House Bill 1024, by Representative Rice of the 51st and others. Bill to be entitled an act to amend an act providing for a budget commission in certain counties based upon classification by population and for other purposes. Committee of the Senate on State and Local Governmental Operations recommend that this bill do pass by substitute. Senate State and Local Governmental Operations Committee offers the following substitute to House Bill 1024. Bill to be entitled an act to appeal an act providing for a budget commission in certain counties based upon classification by population and for other purposes.
Chair recognizes Senator from the 49th. Present the bill.
Thank you, Mr. President. I bring to you House Bill 1024. This is of urgent and dire need. This repeals an act creating a budget commission for certain counties approved in March of 1953. And it repeals an act creating a budget commission of certain counties having a population of 600,000 based on the census of 1930. We've been waiting a long time on this one. Exactly. And it preserves the current method of budgeting for Gwinnett County and counties with a population of 600,000 or greater by repealing the 1953 Act. If there are no questions, I will vacate the well.
Do us all a favor and vacate the well. Questions on the adoption of committee substitute. Is there objection? Seriously? There is objection. No, he's objecting to the committee substitute. Senator, you're in agreement with the objection. There is objection. Is that's interesting. Is there objection to the objection? No. Yeah, I put it out. All of those, the author is in agreement with the objection to the committee substitute to go back. All those in favor, Senator from the 9th, what purpose you rise?
Could we just suspend for a minute and understand? I know there's two people in this room understand what we're doing. but could we suspend for a minute to, or maybe get the senator back in the well to understand why we're going back? You know, maybe I was sleeping and I didn't hear that, but I'm trying to figure out why we want to go back to.
Yeah. Senator from the 38th, you wish to state your inquiry. Okay. Let me make sure that I explain the posture by which we are in. We have an underlying bill that came over from the House. There was a committee substitute, that is the green one before you, which passed out of committee. The senator from the 56 and the senator from the 49 are in agreement, are asking to defeat the committee substitute and pass the bill as it was passed in the House. Okay?
Parliamentary inquiry.
State your inquiry.
Would it be appropriate this time for me to make a comment as to what's going on regarding this, since it is affecting Fulton County?
You can certainly speak to the bill, yes.
Thank you.
Chair recognizes Senator from the 38th to speak to the bill.
Well, here we are again. Here we go again, beating up on Fulton County. We had an agreement. It was brought forth, 1024 was brought forth in committee. It was a simple proposition, as you've already heard from the senator that introduced the bill. All Gwinnett was trying to do was raise the population number so that they would not come under this antiquated bill that was passed in 1953. In committee, it was brought forth that they made an amendment to take it from the 900,000 that came over from the House to $1 million, which at that point would exempt Fulton also. Well, in discussing it with legal counsel, it was felt that since the bill is antiquated, that if we repeal the language, which everyone agreed to, then that would take care of Gwinnett's needs, that would take care of Fulton's needs. That would just repeal it so that Fulton, at some point, what they want to do is possibly change their fiscal year. The bill is the way it is now, will now allow us to do that. So all they wanted to do was repeal this language so that Fulton wouldn't come up under it, Gwinnett wouldn't come under it, and the problem would be solved. So why I'm saying here we are again, we just did this for Augusta. We keep going back and doing egregious things to members of this body, to our constituencies. We continue to ask you to be fair, And the fair thing to do would be to just go on and repeal this. So I ask you not to overrule the objection of the senator from the 56, but allow us to stay with the sub that came out of the committee, out of SLOGO, so that handles everybody. Gwinnett is handled, Fulton is handled, and the others that may reach that population level, if we continue to have this piece of legislation, would not have to be subject to this. So I ask you once again, seems like we do this once a year, something comes up where we have to come down and ask you to be fair and do the right thing. And I'm just asking you to be fair and do the right thing. If there are no questions, I yield the will.
There are no questions. Well, I'm sorry, there's a question, Senator. Chair recognizes Senator on the 6th for a question.
Yes, I yield.
Yeah, you yield. Was it not true, I'm also a member of SLOGO, is it not true that we had, obviously the House representative was there. This wasn't something the SLOGO committee did in the middle of the night. We had an honest, open discussion with the House representative, and we came to this agreement.
Yes,
that not true?
that is correct.
I just want to make sure that was clear.
Thank you.
Chair recognizes Senator on the 14th.
Will the senator yield?
Yes, Senator.
So the position you want us to take in respect to Fulton and Gwinnett is to support the sub as it came out of the committee as the committee chairman presented it?
Yes, sir. Thank you.
Okay, this is the question now is that the senator from the 56th has objected to the adoption of the committee substitute. All in favor of the committee substitute? Follow me. If you are in favor of the committee substitute, vote aye. Those opposed, no. Secretary will unlock the machine. If you're in favor of the committee substitute, vote aye. Chair recognizes Senator from 56.
Mr. President, parliamentary inquiry.
State your inquiry.
Isn't it true that the representative who authored this bill has asked for this change and that a vote no or red would be consistent with what the author's intents were and doing the best for the county and the Senate?
I'm sure the senator knows from which he speaks. Chair recognizes Senator from 33rd.
Is it not true there's a House of Representatives and then there is a Senate? And if we want to uphold the opinion of the senator from 38th, we would vote green to approve the committee substitute. And the 49th.
Senator has great passion for this issue as well. You have not voted yet, however, Senator. Steve? On the motion, on the adoption of the committee substitute, the yeas are 19 and the nays are 29, and the committee substitute has failed. Chair recognizes Senator from 33rd. What purpose do you rise?
I know that it has to be immediate, but I would ask for reconsideration. Somebody needs to do this session.
That motion would be in order on the committee substitute. The senator has moved for reconsideration. If you are in favor of reconsidering the actions of the vote that was just taken, you will vote aye. If you are opposed, you will vote no. Secretary will unlock the machine. Chair recognizes Senator 56.
Parliamentary inquiry, Mr. President.
State your inquiry.
Isn't it true that we'd like to vote red on this bill, on this motion?
I think you've been very clear on your position. Chair recognizes 726.
Correction, parliamentary inquiry.
State
Mr. President.
inquiry.
Correction, isn't it true that we should vote green on this amendment? Substitute?
I think you've got a lot of passion, but I'm afraid it's going to come up just a little bit short. The yeas are 17, the nays are 32, and the reconsideration of the committee substitute has failed. Now, this takes us back to the underlying bill, the House bill as passed, final passage. Does any other senator wish to speak for or against the bill? Is there objection? Agree on the report of committee which failed pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put or the objections? Chair hears none. All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. For planning purposes, we will be taking a break. Is the House still in session? No? They've taken a break? How many breaks have they taken today? How many Senate bills have they taken up? Does anybody know? Pass the bill, the yeas are 34 and the nays are 15. And this bill, after Rex constitutional majority, is therefore passed. Senate will stand at recess until 6:30.
Ligon's got a bill coming over, 332 or something. And then the House is going to agree with the amendment. The tax bill, got a working agreement between the ACC and the they've come to a new agreement. So we're going to, and his bill is local option sales tax